My lord, may I permitted to mention one matter, my lord?
One. What is the mistake?
So I don't remember what Mr. Bishwa's, at Mr. Bishwa's instance, it was kept on Monday, Lordship. I'm praying for a short password because the office was closed for last 2 days, and can it be taken up at 2 p.m. Lordship, 2 p.m. or 3 p.m.?
দুটোর সময় কি আছে?
It is a very short issue, Lordship. It can be resolved. There is a part at 2 p.m. our matter and 3 p.m. also our matter.
Oh, ঠিক আছে।
2 p.m. Lordship. Grateful. দুটোর সময়।
Correction.
I think 200 I am for the petitioner, not my behalf matter has been listed.
You have not mentioned?
No, my lord. Most probably state advocate name problems.
দেখো কে মেনশন করেছে এটা? উকিল বাবু সই, ফোন নাম্বার সব থাকবে মেনশন ইনক্লুড। এটা কেন এই সিস্টেমটা পাল্টালো কেন? না, এখানে এ তোমার রেজিস্ট্রেশন নাম্বার যেটা আগে বলে দিয়েছিলাম, দ্যাট উইল বি ফলোড। দেখা ওনাকে কে মেনশন করেছে আমি জানি না।
State. Most probably state advocate mentioned. Subodip.
What is the correction? কারেকশনটা কি আছে?
Lordship, in this matter, Lordship,
বলো কি হয়েছে?
my title of the name is mistake, your Lordship. It will be Moitro, your Lordship, instead of Mitro, your Lordship.
That is appearing under the edit to be mentioned. Inadvertent typographical error is scraped into order dated 20th February 2026, mentioning the name of learned advocate for the state as Shubhodip Mitro instead of what is the spelling of Moitro?
Moitro, M-A-I-T-R-A.
M-A-I.
M-A-I-T-R-A.
M-A-I-T-R instead
It
of
will be S2BH or it will be S2BHA, your Lordship.
লিখে দাও।
the full name. Do you know? Give your name in capital. Write it in capital.
ক্যাপিটালে লিখে দাও।
Okay, because
The name of the learned advocate in the aforesaid order be read as Subodip Moitro instead of Subodip Mitra. The other portions are modified. Right.
ভালো করে লিখো।
I am appearing for the alleged contempt, matter.
The writ petition, it was disposed of on 8th of August 2025. With the direction upon the respondent number 3, the executive officer of Mohammed Bazar, Dubrajpur.
That you consider dispose.
Dubrajpur Gram Panchayat.
Also-
Thereafter, on 13th of August 2025, the order was communicated to the concerned respondent authority. But thereafter, my lord, till date, the order has not been compliance by the authority. My lord. On 25th of 11.
Where is the
November,
order? Order passed, what is the contempt then? There was a direction to dispose of your representation. If that is disposed of, then nothing remains in the court.
Post of, my lord, your lordship will find, my lord, your lordship, the order starts at page 16, relevant is page 17, my lord.
Yes.
What is the order passed?
My lord, your lordship directed the respondent number 3, the executive officer Dubrajpur Panchayat Samiti, to consider and dispose of the representation of the petitioner, the second last paragraph. Now, my lord, your lordship will find, my lord, from this contempt application itself, my lord, that he was directed to appear before him, and thereafter, my lord, it was found that he is entitled to receive a sum of rupees 4 lakhs and odd. Your lordship kindly consider the order at page 27. My lord, the executive officer requested the district magistrate, my lord, to release this fund, my lord, under the, kindly consider, my lord, page 27, last paragraph, my lord.
Yes.
Under the circumstances, you are requested to take necessary steps to allot rupees 4,97,528 only to this office so that the payment may be made. Now, my lord, thereafter, my lord, at least 3 reminders were issued. I have, my lord, may I hand over, my lord, this relevant document? Thrice, my lord, it was requested to kindly release the payment. District magistrate, my lord, was requested. My lord, there are 3 letters. One is 11th September 2025, then 5th December 2025, then again the third reminder on 5th March 2026.
Then if it is found that the applicant is entitled to, why the district magistrate not allotting the fund?
My lord, there is one difficulty, my lord, that Paschimachal Unnayan department, my lord, there is a separate department. The district magistrate also, my lord, issued a requisition, my lord, to release this fund. Now, I do not know, my lord, what happened thereafter, my lord.
File
But
a affidavit informing the court what is the stage of this
Very good,
process.
very
Because
good, yes.
communication has been made from this side of the LS contemptor. So file a affidavit of compliance on the returnability disclosing the facts.
Very,
Huh?
very
What is the stage of payment?
very good.
But filing my affidavit of service.
Affidavit of service filed on behalf of the petitioner is taken on record. Miss Jui Dotto Chakraborty, learned advocate for the applicant, submits that pursuant to order of this court passed in the writ petition, comma, a reasoned order has been passed by the executive officer, Dubrajpur Panchayat Samiti. Though the petitioner applicant has been made entitled to 4,97,000 528, comma, the fund is yet to be released in favor of the petitioner applicant. Mr. Arjun Roy Mukherjee, learned advocate appearing for the alleged contender, submits that several communications have been made to District Magistrate Birbhum and the funds are in the process of being released. He seeks accommodation to file affidavit of compliance on the returnable date. Release this matter after
My lord, 2 weeks or 3 weeks, my lord.
after 3 weeks.
I'm grateful.
Completely operational.
Yes.
Item 5, I am for the petitioner, my lord. This matter relate to issues certificate of DLED, my lord. And last occasion, the advocate who are appear for the NIOS, my lord, take time to file report.
My lord, I am led by Mr. Shiv Shankar Banerjee. He is still in transit to the court. Kindly I pray for short passover, my lordship. He is unwell right now. Pray for short passover.
Passport not today, no.
फिर passport
Today, no.
passport
I can see. You want what? After cut off date. The report file করতে বলেছি।
Lordship, here, Lordship.
6 to
Lordship, directed, Lordship, directed to file a report, Lordship. I am given some time, Lordship, required for Lordship.
how long?
Lordship, as for your Lordships.
How many times this report has been called for from February?
Lordship, give me Lordship 1 week or 2 weeks, Lordship. As for your Lordship convenience, Lordship.
If you really have to file a report, then file it.
Not
Or
necessary,
on
Lordship.
basis of the materials on record, we have to dispose of the writ petition.
Lordship,
Every
give
day
me
you
Lordship
come
one
and pray for
Friday,
the-
Lordship. I am Friday, Lordship. Friday I filed.
I think twice. These all matters of record, no dispute question of fact involved. They're only delaying the matter.
No, Lordship, then no matter,
Okay.
hard the matter, Lordship.
Yes.
Without Lordship, we
Very
report.
good. It can be hard.
Can be
Every
done,
matter
Can be
of
Lordship.
record
Lordship.
can be hard.
Lordship.
Can a similar proceed if either feels any dispute involved, then question affidavit. They've never filed. But this,
But
I-
real Lordship.
If the Lordship and file a report, Lordship, here total judgment of Supreme Court, division bench, all things. Otherwise, Lordship, acha তোর কাছে?
If judgment of
But here, Lordship,
if the reference says-
yes, Supreme Court judgment, division bench judgment, single bench, again division bench, 2 or 3 division bench judgment, 3 single bench judgment, and Supreme Court judgment. I
But-
have, Lordship.
For
But here,
relying
Lordship,
on judgment of court, you don't have to file any report or any affidavit.
here, Lordship, I have not
File it, you
ready,
cite the
Lordship, I am
judgment.
not ready to file any Lordship judgment. My junior says, Lordship, give me if the Lordship Thursday or Wednesday, 1 day time, I file the report, Lordship. Affidavit only for the Lordship already complete. 1 day time, I am.
Monday, coming Monday.
করা যাবে, right? Must be-
আনসার্টেন যদি কোর্ট না হয়
This is 2009.
Thank you.
2009. Lordship,
May
here,
we have been
Lordship,
granted-
Friday I have no objection, but here, Lordship, I have the Ram Navami High Court declared Thursday. But our bar association, Lordship, were 27 Friday.
No, no, we are not in Ram Navami now.
Lordship, give me the Friday, I have
Monday,
no.
Monday.
Monday, Lordship, Monday. I am thick Monday.
No, no, first of all, থাকবে miscellaneous তো।
আর কিছু করতে
First of all থাকবে।
Monday করে
Mr. Oicho, learned advocate appearing for DPSC,
Lordship,
Proceed.
District Primary School Council.
DPSC North 24 Parganas
আমাকে এটা report
seeks
দিয়েছে।
accommodation to file report in terms of order dated 6 February 2026. Please this matter on
ঢুকলে
বল। Monday. Monday?
But I am appearing my lord 8, 9, 10, 11, 12 and 13 my lord.
Six
5
to
21.
22.
From 6 to 21, all the matters are same.
Yes, sir.
We will-
And maybe
No, I am ready, Lordship, but I have no objection, Lordship. But here, Lordship, judgment is.
Mr. Oicho,
judgment. you
But
can
here,
cite
Lord, if the. yes,
court also
if the
requires for the
Lordship-
convenience of disposal of the writ petition requires a report.
Lordship,
Opportunity
That
has been
Lordship,
given to you to
Monday,
come
Lord.
up with the report so that you can also make the submission and dispose of the report.
No. Without judgment, Lordship, it is the total case is depend upon the judgment, Lord. Yes. আমি তো রাজি আছি
Please come on Monday.
লর্ড
Good.
22.
এটা একটু দিয়ে দিন
ওটাই 21টা আইটেমই তো আছে,
কি থাকবে
21টাই আছে তো ওখানে লিখুন।
সার্ভিস দিয়েছিস তুই আমাকে টাইম করা আমাকে টাইম করা হয়ে গেছে এক্ষুনি দেখি
22, I am for the petitioner, my lord. But this matter was taken up by your lordship on the Friday, my lord, wherein a point has. But this is my affidavit service. But on Friday, my lord, your lordship was of the opinion that this.
I appear with the state respondent 6 to 14 22 চলছে না দেখি নাম করে সমস্যা করে কাগজ
But possibly, my lord, your lordship was of the opinion that this matter pertains to secondary. Now, my lord, this matter was running before the Honorable Justice Amrit Sinha when her lordship was having the determination of secondary. She released the matter on the pretext that this matter pertains to primary. Therefore, my lord, my lord, we had mentioned before your lordship for inclusion upon notice to the other side.
You tell me what under which it is primary or is secondary?
Well, it's
Substitute teacher of high school.
yes, my lord.
So
It
how
was.
primary? How primary will come?
Now, my lord, he was a assistant teacher of work education, my lord.
Work education.
Yes.
Now, work education means how this is distinguished from a primary and secondary. You are for the state.
no my lord previous matter
The point that has been raised by my lord,
Come to your
because
prayer.
it is a secondary department, because the notifications which I am assailing before your lordship is from the secondary education.
So how the primary?
Yes, my lord, I need to get it assigned and my lord,
Then I'm releasing the matter. Right?
my lord, yes.
Mr. affidavit
The
of,
last occasion, my lord, kindly record, my lord, this matter was released by the erstwhile bench on that pretext, my lord, also.
I don't know what is it. Only it says that it does not have the determination.
Yes, my lord. She was, my lord, her ladyship was having the determination on secondary, my lord,
Carried out by
upper primary.
examiners carried out by learned advocate for the purpose of changing group to secondary to. The report has also been given that you have changed it from secondary education to primary education.
Yes, my lord, because of the
But there is no
order.
such change. You have changed.
I'm told, my lord, that has been changed, my lord.
But where have you written? You have changed the presentation form itself or corrected on the earlier one?
Possibly corrected.
Huh?
22 number.
हाँ 22 number. A primary matter, sir. But it's a primary matter, but my learner's friend is appearing, my lord.
No, I'm not appearing for
He
the.
cannot decide the determination.
Secondary board actually.
Secondary board. He's appearing for the secondary board. So it has to go to the bench.
Mr. So-and-so learned advocate appearing for the petitioner submits that the matter pertains to secondary education.
না না এটা প্রাইমারিতেই হবে
As such,
এসএলএসটি
But
বলে
he's saying, my lord, the matter will be in primary.
That relates to primary,
Huh.
but since the teachers were previously working in second SLST, those job were provided by the secondary board. So the matter will be primary.
I cannot follow you.
The petitioners were working in second SLST recruitment process previous. So that's why secondary board has been made a part. But now they are praying for appointment in the primary school.
Perhaps,
Come
my
to
lord,
prayer A. Prayer A. Prayer A of the writ petition. Can this court reinstate them to HS, higher secondary school, not having determination of a secondary education?
Your Lordship, in the post of primary teachers under North 24 Pargana District Primary School Council.
not 24 Parganas monitor.
Which matter you are, which is the writ petition? 29168.
13170.
Get the numbers.
Oh no, it is separate.
It's a separate matter. But perhaps a report from the OSD would suffice, my lord.
Why to keep this? Because your case is that you are.
I was working. Simultaneously, my lord, an order passed by this court wherein I was arrested. Thereafter, my lord, disciplinary proceedings initiated. But no info, no
You
national
are challenging the disciplinary proceedings
Yes,
while you are discharging as a
assistant teacher.
in the higher secondary school.
Yes,
In this court. Submits that as such this court lacks determination.
It's a DP matter. DP matter.
Where is the order of suspension?
my lord.
So
If
far.
lordship kindly takes up
Page 76.
yes, my lord.
It has been issued by the secondary education. No. As such, in view of the above, the matter is released from the list of this court. Keep this affidavit of service on record for want of determination.
But kindly place the direction upon the OSD, my lord, so that we can apply before them.
No, you apply.
My
I
lord.
cannot say so.
Grateful, my lord.
Next.
Grateful. Answer.
ওটা আগের অন্য ম্যাটার ছিল ব্রিফ অন্য আসছে
Your Lordship, I am appealing for a secondary. I am appealing for the secondary report. I think
22. Huh? Oh. Yes.
Apply for the state.
None appears. কেন সাবমিট
কেন?
টপে এসছে এগুলো মেনশনিং স্লিপ গুলো রাখছো না কেন?
23 হচ্ছে তো দাদা।
টপ দেওয়া আছে, কেউ নেই। ও আচ্ছা। None appears on behalf of the petitioner. Oh. Normal করে দেবে। List this matter after 2 weeks.
কেন?
2 সপ্তাহ পরে লিস্ট। হ্যাঁ, এরকম মিস করে গেছে, টপে আর দেবে না। নেক্সট।
Under 24, I am for the petition.
I am the state respondents.
Before my management places the petition, well, this was, leave was taken on Friday. Moved today because the interview is tomorrow and day after tomorrow. He has not passed it, but he says he had already passed it. So, Malad, I will get the instructions by today. Kindly take it up tomorrow. If he Malad finds that he is right, then we will allow him to sit for it.
Okay.
If otherwise, I will accordingly.
Affidavit of service filed on behalf of the petition is taken on record. Mr. Subir Sandal,
Yes.
senior advocate appearing for the West Bengal Board of Primary Education, seeks accommodation to take instruction. List this matter tomorrow. এইটা কালকে 2টোর সময় দেখুন তো, কালকে 2টোর সময়। হ্যাঁ, এটা 2টোর সময় কালকে থাকবে। কালকে পেনশন ম্যাটার্স আছে, এটা
They are the material, the state has no role at this time. They are the material respondents, Board of Primary Education.
tomorrow
Fix it so that your losses can hear it out. Just for
2 p.m.
Tomorrow at 2 p.m.
এইটা আগে দিয়ে দেবে। হ্যাঁ, এই অ্যাকোমোডেশনটা এই শ্রীমানি 1 day accommodation, P6 1 day accommodation পেটে গেছে। কত নম্বর আইটেম?
Well, 32 to 34 are all similar. If your losses kindly takes it up 34.
34. You are for the petitioner in all these?
Petition.
no, only
34, but that's the leading matter. My learned friend will get the benefit of.
No, 32 you are there. 33 also. এটা 34 টা দিতে বললেন।
Your losses and
34 টা দিন।
এটা 34 এর তো?
Yes.
You also got 34. Now your losses, I think your losses, just give me 2 minutes time. Your losses has dealt with by way of this supplementary affidavit. We have annexed the parent order of Justice Mantha and your losses order both. Your losses kindly consider page 7 of the supplementary affidavit. Justice Mantha's order dated 24th April 2024. Your losses, the paragraph your losses will be getting 13. Page 14, running page 14. In the above circumstances, following the order dated such and such for the reasons stated herein, in respect of DPSC Howrah, this court by consent of all parties is inclined to direct that all candidates who were called for interview in the aforesaid recruitment process of the year 2009 and have filed
writ petition until 24th April 2024. My lord, our writ petition is, my lord, of 2019, my lord, and this is in regard to the same panel, and we paid for appointment and participated in the interview also. Shall be entitled to appointments. We have annexed the documents also. I will take your losses just now. Shall be entitled against existing or future vacancies. Now your losses, before going to your losses order, kindly take up the writ petition page 38. Interview letter.
Yes.
That's your losses prayer A. To publish the approved panels for different categories and to issue the letter of appointment to your petitioners within a specified time from the date of publication of such a result. Now the interview letters, kindly have a look at page 209 onwards. We have annexed the interview letters. This is in regard to District North 24 Parganas. Page 209, annexure P6 onwards. Those are the interview letters your losses will find. 31st October 2014 onwards.
This is a petition number 1.
Bappaditya Ghosh.
Okay.
Well, they will cross-verify it. Certainly, if I make a false statement, certainly they will not.
So this writ petition has been filed prior to 2024, but cut off
Yes,
date.
yes. Well, this is
29.
29.
And they have all been called for interview.
All right.
So they qualify those two conditions.
Now your lawsuits order, Justice Manta's order at page 14, I placed before paragraph 13. Now page 15, running page, paragraph 15. Just your lawsuit, paragraph 15 onwards, the verification of records. This is in regard to District North 24 Parganas. And this judgment of Justice Mantha also in regard to North 24 Parganas. Paragraph 15 onwards. And your lordship's order at page 18.
Yes.
Your lordships has given the entire details. Now, paragraph 7 of your lordship's order, page 21. Upon hearing the learned advocate for the following issues are fallen for consideration. 1, whether the instant writ petition is maintainable or not, or whether the petitioner's numbers. The maintainability of losses ground. And secondly, seeking appointment, need to file a separate petition, all that. Now your lordships. There is the ground, the point taken in that writ petition, that suppression of fact, that your lordships completely discarded. Paragraph 9. Page running page 23 of your lordships order. With regard to issue number 2, it is found by the order dated 26th April 2024. I placed 25th, even the earlier order. Both the order at this spot. The coordinate bench of this court, after considering the irregularities in the Recruitment 2009, directed us as follows. In the above circumstances, following the order dated 9th April 2024, for the reasons stated therein in respect of District Howrah, but the first matter was of Howrah. This court, by consent of all, inclined to direct all candidates who were called for interview in the recruitment process of the year 2009 and have filed writ petition until 25th April shall be entitled to appointments against exist. These are the two kinds. Therefore, I am entitled against the existing vacancy or future vacancies as well as.
Malad, I appear on behalf of the DPSC, Malad, not this one.
Yes.
Malad, I'm paying for time for taking instruction, Malad, file a report, Malad. Because, Malad, 25th April, the Honorable Justice Mantha passed an order, Malad. Thereafter, Malad, time was extended by his lordship, Malad, Mantha's. Malad, 8/7/2024, Malad. Lordship, kindly see the order. Time was extended, Malad. Internal page 2, paragraph 5. It is also made clear that no further repetition in respect of the recruitment process of the year 2009 conducted by the DPSC Malda North Chobbish Pargona, Howrah, shall be entertained beyond 31st July 2024, even if the repetition are filed within the cut-off dates mentioned in the orders relating to the said recruitment process for the aforesaid purpose. Now, petitioner filed this petition, my lord. 22nd November 2019, my lord. Petitioner never come, my lord. Within cut-off date 24th April 2024, my lord. Thereafter, lordships extend the time, my lord. That's it. I'm paying for time for file a report, my lord. Very short time, only 2 weeks, my lord. Thereafter, decide.
What report you will find?
But as per lordship's order, my lord, those petitioner appear before the verification date and appointment already over, my lord. No vacancy, my lord. I take instruction and thereafter.
This was not against future vacancies also.
Yes, any future vacancy.
What are your petition?
Here, I am take instruction or come back. 2 weeks. If the lordship direct a report, otherwise lordship take instruction. and move the matter.
But there were direction to file affidavit in opposition also.
Opposition.
Justice.
Justice. তারপরে তো মান্থা অর্ডার হয়
হ্যাঁ কিন্তু এফিডেভিট তো মেন ম্যাটারে কোনোদিনই দেওয়া হয়নি
then give me lots
আবার
sorry
extension.
no extension for 3 weeks time then file the affidavit opposition
Then your losses stay their hands for any appointment.
no lordship 3
They should not be allowed to make any appointment.
no lordship that
One
lordship I am
cannot
giving
go on.
tell lordship matter will hard lots on merit give me 2 weeks time on merit I will
Do that even Malad, in that case I'm praying for an interim order now.
no lordship I am opposed this interim order
My
lordship.
learned friend
What
opposite.
type of interim order will he
No further
Supplementary
appointment.
affidavit.
no that lordship
Supplementary affidavit.
if the matter
You will not be filing any opposition, but you will file report.
But lordship, if the lordship, as per your desire, if they give me the opposition 3 weeks, report 2 weeks, lordship.
Oh,
As per
it's
the
not the desire of the court.
That's
Court
why
gave
the
you opportunity to file opposition.
File the
Now from 2020, the opposition has not been filed. You are submitting that you will be filing and report.
No,
Now it is up to you whether you will exercise your liberty or not.
Court the lordship, here the honorable court filed the opposition, I filed the opposition.
And the other matters, there was direction.
That's all it is there.
In order to next matter also there is a direction for filing report, my lord.
Then lordship, give it report 2 weeks, otherwise opposition I file. এখানে উইকে লজ্জা লাগে বারবার সময় চাইতে
A supplementary affidavit filed on behalf of petitioners. As on the prayer of an advocate for the petition, leave is granted to file supplementary affidavit. Supplementary affidavit filed on behalf of the petition is taken on record. Copy served. Give a copy.
Yes, yes, I've got it.
It is 34 হচ্ছে order.
নিবে তো উনি সাবমিট করে নিতে
32 or 33 টা দেখছি। Mr. Boishul, learned advocate. As Mr. Subir Sandal, learned senior advocate, appearing for the petitioners. How many petitioners are there? Petitioners.
14
Submit that.
fee is not submitted or not, I don't know. Fee দিয়েছে?
Petitioners stand on the similar footing
Fee দিয়ে দাও।
as of the petitioners in WPA 20624 of 2019.
বাকি কেন কি?
তার আগের অর্ডারটা ছিল and WPA এটা আগে দেবে WPA 11750 of 2024. Disposed of by a coordinate bench of this court on 24th April 2024. It seeks that similar benefit be extended to the petitioners. Mr. Boisho, Bhaskar Prasad Boisho, learned advocate, seeks to file, seeks extension of time to file affidavit in opposition. 2 weeks, 1 week, 3 weeks পরে লিস্ট করবে উপরের দিকে। হিয়ারিং এ রেখে দিলে হয় কোশ্চেন রেখে কি করব হিয়ারিং এ রাখো
But only one thing in respect of the item number
34.
Bappaditya Ghosh 34, your losses kindly take up the supplementary affidavit I have filed. Malad, except these writ petitioners, all other writ petitioners do not proceed because they have already appointed. Somehow they have got appointment in various process might be, so they do not want to. Malad, kindly confine it to these petitioners mentioned in supplementary affidavit on behalf of the petitioner numbers.
only 47
Only for Malad. Not 41, 2, 3, 4. এটা কতজন আছে?
14.
It's only 14.
acha he further indicates that already some of the writ petitioners have been granted appointment and the writ petition is confined to petition number 3, 5, 13, 25, 27, 29, 30, 30 এখানে দেখে নেবেন এই সাপ্লিমেন্টারি অ্যাফিডেভিট টপে
And in respect of Malad, item number 33, Auditro Ghosh, Mr. Bhattacharya appeared on 12th December 2025 and seek accommodation to file report with verification of the candidature of the petition. But till date, no report, Malad. Can we look Auditro Ghosh,
Seeks
WPA
accommodation
number
file. Where is it?
6097, 12th December 2025. Malad, only 1 week I will involve the matters will suffice. Verification even can
2 weeks time, Lord, otherwise.
Particularly non-joining vacancies.
kindly have a look at this.
Give me 2 weeks time, Lord.
They are only stand of justice subsequent month of the order. I will have make submission. That's the only point. Verification even after your lordship's order can be done. And that is the direction of Justice Mantha.
Then Mr. Boisho come up with the verification after 2 weeks. The other matter, you file your opposition within a week. I give them 1 week time to reply to
Do
that.
that.
Lord, sir, 3
Let
weeks.
these matters come up after
Then,
2
Lord,
weeks.
next week, Lord, I have some personal over the Lord. Lord, I am.
ঠিক আছে is there any change in the number of petitioners over here?
No,
Only single petition.
all the petitioners placing their
Only
case?
single petitioner here.
Single. এটাতে Mr. Bhaskar Prasad Boisho, learned advocate appearing for DPSC North 24 Pargana, seeks accommodation to file report. 3 weeks for it list করে দাও
So I'll kindly shorten little day, 10 days, 3 days after
2
4 days.
weeks.
No, it
10
takes
days.
long.
If the Lordship 10 days, I have no. 10 days, 2 weeks, Lordship.
10 days and 3 days and
no,
then
what I am into is because the other matter I have fixed after 3 weeks. So if these matters are connected with that,
Yes, yes.
then it will be convenient for all of you. That's why I'm asking for 3 weeks. You file your report. List this matter 3 সপ্তাহ পরে একটা hearing it didn't follow. And what about the other matter 31,
But 32, my lord.
32?
32, 33, my lord, I am filing a supplementary affidavit. My lord, the annexing the order passed by my lord Justice Mantha and passed by my lord.
দাও 33 টা দাও
No, no. Auditro Ghosh.
ওটা সাপ্লিমেন্টারি এটা আমাকে
32 এটা 33 তো but supplementary affidavit
My lord, I have him.
আমাকে সাপ্লিমেন্টারি
filed on behalf of the petitioner is taken on record. Copies of ওটা লিভটা দিয়ে দেবেন on the prayer of learned advocate.
32.
32
But
was there
32, my lord,
also
also
file
yes, my lord, supplementary affidavit in respect of some of the petitioners, my lord.
Wait,
Petitioner number 2, 3, 4, 5, 10, 12, 16, 17,
what is
20,
the position over here? You
22.
have filed your opposition.
ফাইল করে দেবো
It will be report, Lordship, junior appellate. Not opposition.
6 to file report. Let such report be filed
Lordship,
by the
kindly direct me to supply the
Yes,
copy
my
of the
in course of the day, my lord, I am circulating. I am circulating, my lord, the sub copy of the supplementary.
But here, Lordship, one read petition, 30, 40 read petition is there. Sub court fee, Lordship,
My
direct.
lord, I shall. My lord, I shall.
সবে ডিরেকশন দিয়ে দাও কোর্ট ফিস
Court fee.
It
13th April.
and my lord, one thing, my lord, the non-joining vacancy may be disclosed before my lord, my lord.
There is no vacancy.
So, ye,
in my
Mr.
report.
Sagal arguing the other matter that there are he traced documents, I suppose.
Other matters আছে.
What is this?
My supplementary affidavit in respect of item number 32, my lord.
Give that.
না না করুন
Your Lordship, I
32.
will permitted to item number 23, Your Lordship, somehow missed it. I humbly apologize for that. You may kindly take up the matter today, Your Lordship. Item number 20.
After 2 weeks. No.
Your Lordship, it is extremely urgent, Your Lordship. Tomorrow is the interview, Your Lordship. If it is not taken up, Your Lordship, petitioners will be rendered defenseless, Your Lordship. May kindly take up today, Your Lordship.
Sir, wait, sir, please. এটা কত number item? 35.
I am for the petition in this matter.
Wait. Who is for the other side?
The page 23, this is with regard to my letter of the
Letter of?
page 23. Call letter for interview of higher test for recruitment in the post of assistant teacher in the primary school. That is on 19th of May 2023.
The application recruitment are invited. This is
He has participated. My lord, this court seat at page 22. My lord, he got 82. My lord, thereafter, my lord, this is my lord,
which
page
is
22. My lord, 1, 2, 3, 4, 5, 6, 7, 8. My lord, 8, my lord, from the bottom, my lord. OBCB. My lord, what is my
82.
My lord, the appointment letter, my lord, with regard to my lord, the 6 marks, my lord, that was not been, my lord, awarded to him, and that is why he not come into the zone of, my lord, the issuance of appointment letter, my lord. My case was, my lord, kindly see the I also, my lord, want to use a supplementary affidavit disclosing certain documents with regard to, my lord, the latest judgment on this matter. Give me, my lord, 1 week time, my lord, I shall be produced on these documents also, my lord.
Which document?
My lord, with regard to, my lord, this recruitment process. And my lord, the petition was, my lord, subsequently, my lord.
What recruitment process? Which is the supplementary affidavit containing what? What is not there in the writ petition?
With regard to, my lord, the ultimately, my lord, the 6 marks, which is, my lord, that was awarded to all the candidates, so the petitioner was deprived to get the my lord, the marks of, my lord, 6 marks. My lord, the document with regard to, my lord, the petitioner was subsequently again he has called for. That was not been, my lord, disclosed in the writ petition, my lord.
Fees are scored in 2014. And if the 82 includes 6 marks,
then it will be only 82 to 88. Then, my lord, I should
no, if the 82 includes 6 marks, then
that was my lord, in I made an application under the right to information act. That was I want to, my lord, disclose through a supplementary affidavit.
What is
my lord, this document, my lord, I got instruction. Today is not with me, my lord. That was I shall come back with your lordship, my lord, with this supplementary.
What is the case?
Really, my lord, I believe, my lord, he has not properly instructed to file this writ petition. My lord, he passed it.
Yes.
So now there is no question of awarding of another 6 marks. He passed it with 82. He appeared, my lord, participated in the selection process of 2022. My lord, your lordship will find from page 23 that he appeared in the interview of 2022 recruitment process pursuant to the notification of 29th September 2022. My lord, it concluded with logical conclusion. My lord, everything is over. My lord, even panel has expired. My lord, what remains more? My lord,
he made an application, my lord.
What is your prayer?
My lord, making any application, my lord.
And my lord, that was been replied also.
Everything is in the website. All the panels, my lord, even I tell your lordship, after the 2020-22 recruitment process, there are not a single writ petition is before this honorable court challenging the panel.
No, my lord, my case was that even, my lord, I page 82, the low marks which has been, my lord, awarded, they have been, my lord, issued the appointment letter, but I was not been issued the appointment letter in spite of, my lord, obtaining the mark of 82 marks. That is my case. The other person who have been, I am the OBCB. The other person who have been got less marks than me, they have been, offered, the appointment letter, but I, 82 OBCB.
Well, I didn't show a single document or scrap of paper what my landed petition saying from the
that is my
that less marks was given appointment.
That is my case also, my lord.
Given appointment from the writ petition or, my lord, on the statement he is making that I have not given appointment and the less meritorious, less marks was given appointment, let him show, otherwise your lordship will not impose cost. But if you can satisfy your lordship.
kindly come to page 6, paragraph 6, page 4, paragraph 6. And paragraph 5 also, my lord.
5.
5. Well, I was not been called for verification, but my lord, kindly, even the petitioner was my lord, scored 82 marks.
So far as 82, even if 82 is concerned, you have been made qualified as state 14.
Yes, my lord, but I was not been called for the verification test.
What is this, my lord? Page 23, he has annexed.
This is
That is interview letter, my lord.
Yes.
But no appointment letter, my lord, with regard to verification of my testimonial, that was not been done.
If you don't qualify after the interview, how come the verification?
But what is the less qualified candidate, my lord, wasn't got appointment?
Where is that appointment?
My lord, that is, I made an application under the right to information, I come with a supplementary affidavit, my lord, that is why, my lord,
this cannot be permissible.
If you have the case that someone with low marks have been
my
given,
lord, kindly adjourn for one day, my lord.
no. If that is your specific case, then you have to plead. Since you have not pleaded, then you have no case.
But
every time you come with supplementary affidavit, change your stance after the hearing is conducted. That is not the.
No, my lord, that is why, my lord, in the beginning, my lord, I said that the page 22, my lord, I scored, my lord, 82 marks. Now let them, my lord, 82 marks, my lord, even in, my lord, I have been not been, my lord, offered
And the writ petition filed in 2023. Well, now 2026.
No, my lord, what is happened in this matter? My lord, there is a, my lord, this writ petition was ultimately dismissed. Thereafter, my lord, by Justice Ashokar Mantha, my lord, Honorable Justice. Thereafter, the order was recalled, and the writ petition was, my lord, taken up for appraise by hearing by Justice Ashokar Mantha. Initially, my lord, when the panel was published, immediately, my lord, I filed a writ petition.
Where is the order of dismissal?
The writ petition was dismissed on, my lord, on 20th of February 2024.
20th. Even if that your case has been reviewed and recalled, order has been recalled.
Yes, my lord. And
where is your document showing your grievance?
And my grievance is that, my lord, subsequent, my lord, the letter which is not even annexed in the writ petition, my lord, I want to disclose through an supplementary affidavit. Because after the filing of the writ petition, my lord, this document, my lord, was I made an application under the Right to Information Act. My lord.
Let us, my lord, go to the pair of the writ petitioner, my lord. My lord, page 9, my lord, the mandamus, associated to act in accordance with law and to publish the result of the interview viva voce. But the first pair, my lord, it was published in the website. My lord, this is a, my lord, the recruitment process where the after publication of the, my lord, panel, not a single writ petition is filed challenging the panel. My lord, then your lordship post of primary teacher in the year 2014. My lord, absolutely baseless pair. I do not know what is the recruitment of 2014. There is no such recruitment of 2014. Selection process which was held on 23. There is no connection with 14 and 23 as per the pair A. Absolutely baseless. I believe she should not be joined in the post. But she doesn't know anything ABCD of the recruitment process.
Then
to take necessary steps for giving appointment letter upon the petitioner so that the petitioner be appointed to the post of teacher in the district of Howrah.
The panel, first initially my pair was that.
Keep one post vacant. There is no question of keeping one post vacant. Everything was filled up. Panel expired.
Initially the petition was
nothing. What remains in the writ petition, I am asking myself.
Initially, the writ petition was filed for publication of the with regard to the verification list. The panel. Thereafter, after found that there is a certain with regard to the less marks, which is been then the petitioner who has got an appointment letter. That is he want to make an application under the You want to use a supplementary affidavit through this, disclosing this document.
Writ petition is filed. Seeking for publication of results of the interview/viva for the recruitment to the post of primary teachers in the year 2014 selection process held on 26th May 2023 by the West Bengal Board of Primary Education, and for issuance of appointment letter in favor of the petitioner. The petitioner contends that she participated in the Teachers Eligibility Test 2014 and where is the recruitment process? Which recruitment
23,
process?
this is interview letter.
Recruitment process of 2020.
Page 23,
From page 23.
But you have not stated that you have
No,
participated.
nothing. Your lordship will not understand anything from the writ petition. Top, your lordship,
And
23.
interview letter was issued to the petitioner with a later dated 19th May 2023. However, the petitioner was not granted appointment. Being agreed by such action of the respondent board, the petitioner has preferred the present writ petition. Mr. Lokhikanto Bhattacharya, learned advocate for the petitioner, submits that the candidate with lesser marks have been given appointment. As such, appointment letter ought to have been issued in favor of the petitioner. On the contrary, Mr. Ratul Biswas, learned advocate for the petitioner, board, respondent board submits that the panel has been published and the candidates who qualified has already been given appointment. The recruitment process of 2022 has not been challenged by any of the candidates before this court. There are also no averment to the extent that a candidate having lesser marks than the petitioner has been given appointment. Hence, this writ petition should be dismissed in limine. The precise contention which has been pressed in service before this court is that the petitioner having higher marks than the candidate to have been given appointment. Precise contention is the pressed into service is that the candidates with lesser marks than the petitioners have been given appointment. It is pertinent to note that there is no such averment in the writ petition. That a candidate having lesser marks have been given appointment. In view of the above, the writ petition falls short of merit. Accordingly, is dismissed. এটা কত নম্বর ছিল? ক্যান 2টা দেখি তো কি করেছে? ক্যান 2টা দেখাচ্ছে ডিসপোজ হয়ে গেছে। আবার দিচ্ছ কেন? ডিসপোজ অফ করে দিয়েছে। ডিসপোজ হয়ে গেছে। Yes, dismissed.
Nothing grateful.
This is a matter where the petitioner is a teacher, my lord, in a primary school. Well, initially she was in a school and where that the school was distantly located from her own place. Well, she made an application for the transfer. That application was not acceded up. Thereafter, my lord, she filed a petition before this court and got a direction in her favor that was acted upon by the council, and she got transferred to one school called Vivekananda Institution, Howrah. But the entire problem under this writ petition propped up later when she joined in Vivekananda Institution. My lord, lordship, kindly come to page number page number 31. This is her order by the secretary by which she got transferred to Vivekananda Institution, Howrah. Page 32 is my joining report. Lordship, kindly come. This is to inform you that Srimati Sanghamitra Chatterjee, assistant teacher of Janbar Primary School of Uluberia North Circle under District Primary School Council, Howrah, has joined in our school at 6:30 a.m. sharp on 13/7/2022. Later on, Lordship, kindly come to the next page onwards. She started to face certain problems. The date was, my lord, earlier date 13/7/2022. It was the date of joining. And Lordship, kindly come to the document annexed in page 35. Your Lordship will find the date from the receiving stamp 23/2/2023. She had written a letter to the sub-inspector of school, Howrah Sodor South, under which her present school is situated. My lord, kindly come to the content of the letter. My lord, the main reason of my absence during these days, she was asked that she was not attending the school. Then she explained, I am already sent my absence letter to the teacher in charge of Howrah Vivekananda Institution Primary through message from my WhatsApp. The main reason of my absence during these days for intentionally and malevolently doing ragging and mental harassment in school with me at an extreme level for a long period of time. That's why I was fell sick, and my family doctor told me over the phone to rest for 4 to 5 days and take same medicine, which was continuing after a massive car accident in 2010. I'm already sent my absent letter to teacher in charge of Howrah Vivekananda Institution Primary through message from my WhatsApp. For extension, I have sent a postal letter from India Post, but it was refused by him. I lost my husband on a massive car accident in National Highway near Kolkata, New Corolla PS, Domjur, near Dhulagor Logistics Center, NH6 Dhulaguri, and my 2.5 year son who had gone to ventilation at Apollo Multi-Speciality Hospital and became a special child after the great mishap. But with the care from the doctor I got. Now, Lordship, kindly come here that he is not able to go into the school and became a dropout student. As single parent, I am taking absence for the education and look after his study. My lord, this letter was sent on 23rd February 2023. Thereafter, my lord, kindly come. There was a hearing which was scheduled on 31st March 2023. This was
23rd February 2023.
Yes,
Where is the letter of absence?
My lord,
letter of absence.
My lord, this was sent my WhatsApp. My lord, it is given in page number 33. My lord, these were the documents I've sent. This is on 22 onwards. And thereafter, this refusal letter, my lord, kindly come to next page. That is I have got the documents showing that it was refused by them. My lord will find that 11/1/2023, 11/1/2023.
Page number?
Well,
page number?
Page number, lordship, this is in page 34. 34 is the track report. My lord may recall there is a reference that one letter was refused. My lord, then lordship, kindly come to the latest document which has been given by them to me. My lord, which is in page number 53. Lordship, kindly come. This is a show cause notice which was issued on 22nd March 2024 by the chairman, Howrah District Primary School Council. But at this letter, it is stated that Lordship, kindly come that it is reported by the Sub-Inspector of Schools, Shodor South Circle, wide memo dated 22nd February 2024, that Sanghamitra Chatterjee is absenting herself from school since 28/6/2023 without any intimation to the authority, which is beyond the Primary Teacher Service Conduct Rules 2001 and also hampering badly the interest of the students of the school as well. Under the above circumstances, she is hereby instructed to show sufficient cause positively within 28/3/2024 in writing as to why disciplinary action will not be taken against her as per the rules for such unauthorized long absence and unruly activities as stated above. The concerned sub-inspector of school, Shodor South Circle, is hereby requested to hold salary of the above noted teacher right from the month of April 2024 until further order, and also request to instruct the IIT or HT of the Howrah Vivekananda Institution primary morning not to allow Sanghamitra Chatterjee to rejoin the school without any written permission for the end of DPSC Howrah. My lord, after that I have given the reply in page 54. My lord, kindly come to my reply.
May I just for a minute, to cut short the issue, my lord. My lord, after this letter, my lord, my instruction is, my lord, this old one, but the disciplinary proceedings was initiated. Well, the present position, my lord, I have to take instruction because it is a 24 matter, my lord. My instruction is also earlier, some earlier. Disciplinary proceedings was also initiated. So your lordship, my lord, any day subject to your lordship's convenience the next week, so that I come with the, my lord, the present position, what is the position in the disciplinary proceedings.
DPSC Howrah.
My lord, my instruction is, my lord, we have not been communicated with any such decision of disciplinary proceeding. Let my learned friend bring this records. What is the instruction, my lord? Let it be. I'll be fixed a rate, my lord.
Any day you are subject to your convenience.
Affidavit of service. Chatterjee, affidavit of service.
My lord, affidavit of services are here, man.
Filed on behalf of the petition is taken on record by the present writ petition.
There are two affidavit of service, my lord. This is a old matter. Earlier there was an affidavit of service. Later on, I've given.
Okay. Affidavits of service filed on behalf of the petition is taken on record by the present writ petition. The petitioner's direction seeks direction upon the respondent authorities to issue necessary directions for reinstatement of the petitioner to her position as assistant teacher and refrain from, upon considering her representation dated 29 July 2024 and refrain from taking any coercive action against the petitioner. Mr. Shobhoshaji Chatterjee, learned advocate for the petitioner, submits that the petitioner, pursuant to order passed by this court in WPH 6208 of 2022 dated 10th May 2022, the petitioner was transferred to which school is this?
Vivekananda Institution, my lord.
To Vivekananda Institution, Howrah Vivekananda Institution,
my lord, within bracket
primary department on 11th July 2022. After joining, the petitioner was subjected to several mental harassment and the petitioner was constrained to absent from attending school. However, the petitioner intimated her reasons for absence to the teacher in charge. Without taking any steps, ultimately on 22nd March 2024, a so-called notice has been issued to the petitioner for unauthorized long absence since 28th June 2023. The petitioner has also replied to the said so-called notice on 22nd. This is March or February?
Well, this letter was
22nd February, I suppose. On the same day you have replied.
22nd, yes, ma'am.
22nd March 2024. However, the petitioner till date has not been allowed to rejoin in the school. Para. Mr. Ratul Vishwas, on the contrary, submits that disciplinary proceedings have already been initiated against the petitioner. He seeks accommodation to file report. Let such report be filed within a period of 2 weeks. Advance copy 1 week for exception, if any, 3 weeks for under the heading hearing. For DPSC, only board no, DPSC Howrah. DPSC Howrah. Hearing a date. 13th April.
13th. Every year.
My lord, in 37, my lord, I am for the district primary school council, my lord.
Petitioner has been booked in suspension since September 2023. Thereafter, no disciplinary proceedings has yet been initiated against the petitioner. My lord, kindly have a look, my lord, page number 45. Last occasion, lordship was pleased to
page number
45. Turning page number 45, my lord. This is my lord suspension order. My lord, dated 19th September 23, my lord.
Detained in custody.
In connection with my lord, Kharagpur local police station case number under section 376. My lord, criminal proceedings is pending. Charge sheet has been filed. My respective family, sir, my lord, kindly direct the respondent authority to revoke the suspension order pending disposal of the criminal trial, my lord. I have no control over the criminal trial, my lord.
What
Trial
is
has
criminal
not yet
trial?
been
What is the case?
The petitioner was the primary teacher, my lord. Under my lord.
Why you have been suspended? What is the criminal case?
In connection with my lord, Kharagpur local PS. My kindly have a page. Sunil Kumar Mandi, teacher.
What is the allegation?
Allegation under section 376 IPC. Charge sheet has been filed. My lord, midday meal worker, my lord, husband of the midday meal worker lady, my lord.
Page 38, my lord, the FIR, my lord.
39.
Page 39.
In this, my lord, formal FIR, my lord.
Formal, not only formal FIR, my lord, he was arrested by the police authorities and he was, my lord, in the police custody, enlarged on bail, my lord, after a lapse, after 57 days. And my lord,
this is my lord, formal FIR.
And charge sheet submitted at page, my lord, page 41, my lord.
41, my lord, charge sheet.
Charge sheet submitted. Therefore, the criminal trial is, my lord, pending, my lord.
Disciplinary proceedings have been initiated?
My lord, no disciplinary proceedings has been started, my lord. It is deemed suspension, my lord. And since he was arrested beyond the period of, my lord, 48 hours, and my lord, the allegation, my lord, the charges leveled against the petitioner are serious in nature, not to become, it is not, my lord, good for a teacher, my lord, who is teaching the students in a school. If it is, my lord, otherwise, other charges, my lord, then it is a molestation, and or, my lord, the allegation level against the petitioner, my lord, it is serious in nature. Therefore, my lord, he was, and since the, my lord, all the records and everything, my lord, it is, my lord, subject of a criminal trial, my lord. And my lord, in many cases, my lord, where the charges are leveled against in respect of any other offences,
In that cases, my lord, we have considered where, my lord, disciplinary proceedings has not been initiated. Disciplinary proceeding has not been initiated. Other charges are there, but, my lord, in those cases, my lord, we have given, since we are, my lord, paying 75% of the subsistence allowance, my lord, to the suspended teacher, my lord. In many cases, my lord, by the order of this honorable court, my lord, they were taken into, that was taken into consideration, and they were reinstated in the service, my lord, in many cases. But where, my lord, this type of, my lord, allegation against the, my lord, and the victim lady who is suffered, my lord, and that allegation, it is, my lord, trialable, it is still the trial is going on. Therefore, my lord, in the we have not started any disciplinary proceedings in this case, but, my lord, this is the fact that he is not it is not a good thing for the teacher who is to teach the students, my lord. Therefore, it is not possible for the, my lord, chairman of the DPSC, my lord, to consider his case, my lord. If your lordship, my lord,
report already on record filed by the.
My lord, I have submitted the report, my lord.
Report bearing date, my lord,
10th March, my lord. One page report, my lord. It was filed, my lord.
1 page, yes, my lord.
Shall I hand over one copy, my lord?
Yes.
This was earlier. This was, my lord.
Just settled principle of law, my lord. I have.
My lord, it is not that, my lord. Let him say, my lord, produce one, my lord, judgment where in this type of, my lord, criminal, this section 376 is involved.
My lord, I have 4
Whatever he will produce, my lord, that will under other sections of the criminal, my lord, IPC. But regarding this, my lord, this one, my lord, it is, I have not seen, my lord, that they are allowed.
My lord, nobody should
And, my lord,
in suspension.
I know,
period.
but
As
this
per
type of
existing rule
allegation.
the primary teacher, my lord. I am relying, my lord, 4 judgments. All are pad on the point, my lord. POCSO case is involved. May I be permitted to hand over, my lord? This is, my lord. May I have your kindly my knowledge junior is passed by one of the coordinated bench, my lord. Kindly consider that judgment, my lord. Wherein another 4 judgments of the Supreme Court have been followed. Consider, my lord, follow, my lord.
না আমি বলবো টিচিং করে কি করে হ্যাঁ একটা গাইড My lord, in this matter also, he was, my lord, directed to join, but the respondent authority was shall proceed with the disciplinary proceedings. My lord, that order was given.
My lord, basic judgment of the, my lord, Supreme Court, my lord, Ajay Kumar Chowdhury, my lord. Reported in, my lord, 2025, volume 7, Supreme Court cases 291, my lord.
Charges কি আছে?
Pending disposal of the criminal trial, petitioner may be allowed to join in his duties.
In a similar case, my lord, I shall also submit one judgment of this honorable court, my lord, wherein the prayer for reinstatement in service was rejected, considered and rejected, passed by my lord Justice Amrita Sinha.
Where is that? My lord, may I permitted to hand over the
This one.
basic judgment of the Supreme Court, my lord, reported in 2015, volume 7, Supreme Court cases. Page number 291, my lord. My lord, paragraph 11, 12, 17, 21, 22, my lord. Relevant paragraph, my lord. 11, 12, my lord. 17, 21, 22.
আমি বুঝলি এটা আমার দেখা আছে কেসটা ছিল এগুলো তোমার মানে এটা এটা তোমার এই 376 নাম্বার পস্কো এইগুলোর মধ্যে পস্কো যেটা দিয়েছো ওটা আমারও একটা সিঙ্গেল জাজের অর্ডার আছে
My lord, last judgment may be permitted to my lord, hand over my lord, of this honorable court, my lord. Last judgment, my lord, reported in 2015, my lord, Supreme Court, cases online, Calcutta, 5553, paragraph 8 and 9, my lord, relevant paragraph. Single bench judgment, paragraph 8 and 9, my lord.
এটা 215টা তো দাঁড়াও
Yes.
Last judgment, my lord.
I have handed over one judgment, my lord,
1974,
passed by my lord Justice Omrita Sinha in
paragraph 39,
WPA.
relevant paragraph, my lord, 39.
Oh,
Sorry, 13.
দেখিয়ে দাও হ্যাঁ
13.
Any other thing?
my lord
My lord, rule is silent.
my lord my lord in WPA number 2068 my lord got it yes my lord in this is my lord appropriate and all the sections my lord here it has been my lord charges leveled against the petitioner it has been dealt with and the division bench order and Supreme Court's order also my lord honorable apex court order also considered my lord
By the present writ petition, the petitioner seeks for setting aside and or quashing of the order of suspension dated
19 September.
page number
Page number 45.
42.
45.
45
dated 19 September 2023 or issued by chairman in charge Paschim Mednipur, District Primary School Council, Paschim Mednipur, suspending the petitioner with effect from 1st August 2023. As per Rule 7.2 of West Bengal Primary Education, within bracket, Conduct of Service of Teachers of Primary School Rules 2001. The petitioner contains that he was appointed as an assistant teacher of Washil Chowk Primary School at Lokhon Chowk under Hedgri Circle, Paschim Mednipur, and he joined on, which is date of joining? Joined on 2nd and together. Joined as assistant teacher. No, joined as assistant teacher of home on 2nd November 2012.
Yes.
The petitioner was confirmed in the said post with effect from 2nd November 2014. The petitioner was transferred to other school.
He was
Yes.
transferred from Purbo Medinipur to Paschim Medinipur under Paschim Medinipur DPS.
Photo Purbo Medinipur hobe.
Page number
Hedgri
37.
Circle. Subsequently, the petitioner was transferred to Ambi Jedia Primary School, Paschim Medinipur on 6th October 2020. On 31st July 2023, a criminal complaint was lodged against the petitioner, which was registered as Kharagpur Local Police Station case number 621 of 2023, dated 31st July 2023, under
Section.
bracket within bracket GR case number 2301 of 2023 under section 376 within bracket 2 FN/417/506. The petitioner was arrested on 4th August 2023. The petitioner was put under suspension with effect from 1st August 2023. The petitioner was enlarged on bail on 26th September 2023. Upon completion of investigation, charge sheet was submitted on 4th September 2023 under sections 376 within bracket 2 FN/417/506 of the IPC. Opor Indian Penal Code to within bracket in short করে দেবেন IPC. ওপরেরটা যখন এসছে। The case has been committed to the Court of Additional District and Session Judge Fast Track Second Court, Paschim Mednipur for trial and disposal, which is still pending. There are no discipline proceedings initiated against the petitioner after his suspension. The petitioner, when did you make your representation?
Well, series of representation, my lord.
On 11th December 2023.
Well, first
Date টা আগে দিয়ে দেবেন। On 11th
number,
December
51.
2023, the petitioner made a representation before the chairman, DPSC Paschim Mednipur for withdrawal and or revocation of the impugned order of suspension. It has been rejected or still pending?
No, subsequently, last representation, my lord, 18th September, December 24.
The petitioner
Page number
also made
54.
a representation on 18th December
18th December 24.
2024. However,
That has not yet been considered.
the earlier one was rejected.
No, no, my lord.
Nothing was rejected.
Unattended.
However,
It is not
no
considered.
decision has yet been taken on the representation of the petitioner. Being agreed by the action of the respondent authorities, the petitioner has preferred the present writ petition. Mr. So-and-so, learned advocate for the petitioner, submits that it is settled proposition of law that the suspension cannot be continued for an indefinite period. There has been no disciplinary proceedings initiated against the petitioner. Stop pendency of the criminal trial is not an embargo for reinstatement of the petitioner. To buttress his contention, he relies on the decision of Honorable Supreme Court. Following decisions, following decisions. Ajoy Kumar Chaudhary versus first State of Odisha through its Principal Secretary, Home Department versus Vimal Kumar Mohanty.
Extra copy থাকলে একটু দিয়ে দাও।
Reported in 1994, Volume 4, SCC 126. Of the Honorable Supreme Court. Number 2, Ajoy Kumar Chaudhary versus Union of India through its Secretary and another. Reported in 2015, Volume 7, SCC 291 of the Honorable Supreme Court. Pandito Gangopadhyay versus Allahabad Bank and others. Reported in 2015, SCC Online Calcutta 5553 of this Honorable Court. Coordinate bench of this Honorable Court. And Swarup Chandra Biswi versus State of West Bengal and others. WPA 2304 of 2022. He seeks for appropriate orders for a revocation and not withdrawal of the order of suspension. On the contrary, Mr. Ranjan Saha, learned advocate appearing for DPSC Paschim Mednipur, submits that the cited decisions does not involve any criminal offense of rape. The allegations against the petitioner is serious, and upon completion of investigation and on the basis of prima facie evidence, charge sheet has been submitted against the petitioner. In support of his contention, he relies, and as such, the prayer for withdrawal should be dismissed in limine. In support of his contention, he relies on a coordinate bench of this decision of a coordinate bench of this court in Gopinath Saren versus State of West Bengal and others, WPA 2068 of 2022. বলুন হুম হুম Upon hearing the learned advocate for respective parties, the only issue which falls for consideration is whether the suspension order is sustainable or not. Admittedly, the petitioner was put under suspension upon initiation of a criminal case under sections 376F দেখে নেবেন আগেটা চার্জেস 376F within bracket in 417/506. Upon completion of investigation on the basis of prima facie materials, the charge sheet has been submitted against the petitioner. The case is pending before the learned trial court for trial. One cannot be oblivious to the fact that the petitioner is an assistant teacher discharging his functions, who was supposed to discharge his functions as a teacher in a primary school.
Now he was teacher in charge, as promoted to teacher in charge thereafter.
Was discharging his function as teacher in charge of the respective school. The allegations concerns a grievous one pertaining to commission of rape. The decisions relied upon on behalf of the petitioner does not relate to any of the offences of such nature. And as such, those are distinguishable. Considering the nature of offense, this court does not find in the merit of the prayer. Accordingly, the petition is dismissed. Next.
Number 38, my lord, I am for the petition. And this is my affidavit.
সাড়ে কোনটা আছে ঠিক আছে 3টা ডাকুন তারপর নিচ্ছি এটা পাস ওভার একটা আছে
My lord, in item number 38, my lord, this is my reply to their report, my lord. Though their report was not in the form of an affidavit, my lord, I have my reply.
25 exception to the report.
No.
Who is for the other respondent? Who appeared for the respondent?
Bhatkar Prasad Bush.
সাথে কি আছে সুমন্দি ও কি করবে
My lord, I'm praying for short passover, my lord. Mr. Boyce appear on behalf. My lord,
What is the prayer?
My lord, A category of scale, I was appointed in the year 2003. At the time of that, I was untrained, my lord. In 2004-5, got myself admitted for the training course. I could not qualify in one subject. Again, I gave that one subject in 2005. Result was published in 2011. And I have been granted a category scale of pay from 2016. Since, my lord, I had below 50% in HS and I completed my below 50, upgraded my HS in 2016. I am praying that A category relates to my lord training and not to upgradation of any HS mark. Upgradation of HS is my lord a minimum qualification. This is my case, my lord.
The category scale of pay depends on the training qualification. Training qualification.
Training qualification.
The training qualification is that when you upgrade your 50% marks, then only the certificates can be issued.
My lord, that is with only to in respect of those teachers, my lord, after 2010, because my lord, in 2011, my lord, I had my training, my examination and mark sheet was there. So my lord, upgradation of training was not required. Since my lord, if I do not have the training,
So what was the necessity to have the HS upgraded?
My lord, HS upgradation because the RTA says to be a teacher, you have to have a training, you have to have 50% in HS. So even if, my lord, I have 2 years diploma, then also, my lord, I have to upgrade my HS to 50% because that is the mandate of the, my lord, Right to Education Act framed by the Academic Authority NCT. My lord, HS 50%, what your lordship is saying is absolutely correct. When, my lord, a candidate, my lord, say is appointed in 2010 and he was an untrained candidate and below 50%, he has to undergo both. He has to first undergo 50%, then he has to undergo 2 years diploma through DLM. But, my lord, for a candidate who already possesses the training qualification, then he will get the A category, but he had to upgrade the HS 50% to meet up the minimum educational qualification in terms of the, my lord, NCT and RTA.
When did you complete that training course?
HS upgradation in 2016, and from that date, my lord, I am getting that A category.
So you claim from 2011?
I am praying that, my lord, since 2006, examination not held in 2011, my lord, in this regard, there is a division bench judgment. On this, your lordship also knows that 2005-6 batch examination 2011, the A category benefit should be given from 2006. My case is also false, my lord. My examination.
Okay. I've understood. So it will be from June 2006.
June 2006. Lord, their reply is required. If they
just received the reply, my lord.
Okay.
Thank for
What?
1 week, 1 day accommodation.
What?
1 day accommodation, my lord.
Why?
I just received the reply, my lord. I have to gone through the.
You know your case. Then what new case has been made out in the reply? He has replied to what you have stated.
Yes, madam. But he stated something else. If he stated something else,
New case
then
has been made out.
I'll take instruction, my lord.
What instruction? You have already placed your instruction by way of a report. This is a short point of his entitlement, whether 50% is required for, it will be from date he acquires the upgradation or from the date his training was there.
Yes, my lord.
Which date will be?
From the date of upgradation, my lord.
What?
He is entitled to the category scale, my lord. In 2016, he upgraded his HS qualification and
Affidavit in reply filed by the petitioner is taken on record. Accommodation is sought for on behalf of Mr. Bhaskar Prasad Boisho, an advocate for DPSC Bankura. Next week Monday থেকে next Monday. Fine. এবার তো 20 এর একটা বলছিল তুমি টু বি মেনশনটা রাখো না টু বি মেনশন
number 3.
I am appearing on the school authority.
My lord, we have not fixed it for taking affidavit in opposition. The matter was mentioned on Friday. My lord, they have produced a letter. Petitioners produced a letter.
Passover, my lord. My landed senior meter Biswarup Bhattacharya is engaging in another court. My short passover only.
Not this week, Your Lordship, because the affidavit has not yet been affirmed.
No, that is, I'm not on that. On Friday, this was urgently mentioned when the matter was called on. Because there was a resolution, I put it under to be mentioned. The issue is that before this court, they have handed over the password and the ID. Now, they said they cannot access it until the permission is given by the board. Now they are facing problem in admission of class 9, all this. So board is the answering respondent.
Now this is invalid password because madrasa board has given the password just in front of your lordship, and these passwords totally invalid. This is not being open.
Invalid.
Totally invalid. This is not being open.
Nadim Sulaiman said is appearing in this
registered
matter,
the student with
but
the
he is not present.
As per my information.
Today from midnight, the registration of the students will start.
Yes.
Ask Mr. Sulaiman to come. Or you take the instructions and inform that whether invalid password has been given. Why? It was handed over in presence of court.
Board has issued the letter. Kindly see the letter. What is the guards of the board? I cannot follow that.
Ask him. You take instruction, come back.
Take it in 2 p.m. my lord.
This is user ID invalid.
The board has issued letter. Now the student registration has started.
And password is valid. Certain period are there when the portal.
So why you have invalidated that? If it is for 15 days, extend that.
Yes.
Now every time you invalid and they will come and mention this matter and this matter will go on. No, where is Mr. Sulaiman? Ask him to come. So you take instruction and inform the court why it is invalid. Why the petitioner cannot operate that? Not Wednesday.
Why?
What Wednesday?
Can you see the attitude of the board?
দুটোর সময় কি আছে গো? তাহলে একটা কি রাখলাম না দুটোর সময়? জাস্ট একটা ইনফরমেশন, হ্যাঁ? ঠিক আছে। তুমি বলো 20 minutes পরে 1:05 এই ম্যাটারটা দিই। After 20 minutes you come back, get the instruction. দেখো তো 20 অপোজিশনটা দিয়েছো 23 তে একটা পাস ওভার হয়েছিল দেখি কি বলছো 23 ও 20 অর্ডার হয়ে গেছে তাহলে ও 23 আমাদের তো পাস yes who is the answering respondent here
Lordship,
who is the answering respondent
Lordship, it is the respondent number 126. Lordship, please serve the copy.
who is the answering respondent board
Yes, Your Lordship.
তো ওনাকে একটু বলে দাও কে ছিল
এদিকে
দেখি কি বল you are for the board 23
Party আছে have you served this
Yes.
could you please show me your evidence service
Sure.
board is
Service হয়ে গেছে 126K.
just bring it there
Okay. 456.
It seems that it has been served and the every service shows. But I have no instruction regarding the receipt of the vehicle.
Regional director.
If I may, your lordship, show your lordship the rules, your lordship. Is at page 72.
So what is this recruitment?
Copy neven. Copy neven. Copy. এটা নিয়ে না তো আমাকে নোটসটা আমার নিচে দিই সরি
Oh. Your last date is over.
Your lordship, it's on the 24th and 25th. The
When is the
interview
last
is
date
on.
for filing the application?
Pardon, your lordship.
When was the last date for filing the application?
That's over, your lordship.
How will it be modified?
2025, the first notification, and it has been challenged.
When
in
did
the
you
month
file
of-
the writ petition?
Month of January,
Your lordship,
February 2026.
March 2026.
your lordship will may kindly come to page.
From the month of September last year, he knows this thing.
The date is already over, sir.
Your lordship may kindly come to.
No.
The qualifications at page
Whatever.
74, your
No,
lordship.
no, this cannot. One fine morning you will wake up and file
Your
a writ
lordship, it's on
petition.
the-
When the last date is over, how
The
come?
notice was issued on
No.
the 12th, your lordship.
Why for you the notification will be modified for you?
Notification
Why
59,
the-
2025.
Your lordship,
Why it will be extended? Tell me.
your lordship, on if your lordship
Cause of
may kindly
action
come to
that
page 74,
C
your
date
lordship.
is not being allowed by the board did not accrue in the
Seated
month
was
of March.
your lordship, as per the this gazette notification, seated was allowed.
Hmm.
And thereafter, your lordship, when the latest notification came out on 12th,
This is not in the month of March. You are coming to know that the CTET is not being allowed by the board. Prior to September 2025, I mean, after publication of the notification for recruitment,
yes, your lordship.
you have tried to
We have applied for TET.
apply for.
We have applied for TET. We
Huh.
could not qualify TET, your lordship.
Then
So notification, your lordship, came out on 6th February 2026 for examination.
first notification.
First notification is 15th September.
Page
No.
79, Lordship.
15 September.
The rules came out on 18th March 2025, your lordship. Thereafter, the first notification came out on 15th September 2025 at page 79. And thereafter, your lordship, the TET examination notification came out on 6th February 2026. We appeared for the TET examination, your lordship. We could not qualify, your lordship. And thereafter, another notification came out on 12th March 2026, whereby it has been stated, it is hereby notified at page 88, your lordship. It is hereby notified for information to all TET qualified and trained candidates that selection committee will conduct interview, viva voce examination and evaluate classroom teaching demonstration pertaining to recruitment.
Why did you appear in TET examination when CTET was a definite qualification? Why did
TET
you?
was a qualification.
No, why did you appear then in TET?
We appeared, your lordship.
You have not challenged the rules.
No. We have challenged the rules now, your lordship.
How can you challenge?
Yes, your lordship.
Everything is over. Now we challenge the rules.
Your lordship may kindly come to page 74,
No.
your lordship, once.
This
Your
is
lordship.
telling in both the boards. Now you Why did you appear in TET when you know that CTET is a qualification as per rules? So you
Your
could have
Lordship,
made an application soon thereafter. That the rules does not say that CTET has been made a qualification. So
CTET
this,
was made part of a qualification, Your Lordship. If Your
Just
Lordship
that.
sees page 74, Your Lordship. Name of the post, page 74, 3A. Name of the post shall be special education teacher in primary school.
yes.
B. Qualification for direct recruitment. The candidate must be a citizen of India. Number 2. A candidate before or on the date of submission of his or her application must have obtained the educational and training qualification as prescribed by the central government wide F number 3/3-2021-IS.18 dated 10/6/2022, read with the subsequent amendment, if any, and the said prescribed qualification by the central government is prevailing at the relevant point of time of advertisement for selection for the post of special education teacher in primary school. Now, Your Lordship, this is the first qualification. I will, Your Lordship, show the notification, Your Lordship, which is at page 60. It is part of a Supreme Court order, Your Lordship. The Supreme Court order starts from page 55. It is writ petition civil number 132 of 2016.
Where is the notification?
Notification is at page 60, Your Lordship. Our attention, if I may read, Your Lordship, our attention has been invited to the communication issued by the Under Secretary to the Government of India, Ministry of Education, Department of School Education and Literacy, dated 10/6/2022, informing all the state governments and union territories about the acceptance of the recommendation made by the Rehabilitation Council of India by the department and urging the concerned states, union territories to give effect to the said decision in right earnest and adhere to the directions given by this court in judgment dated 28/10/2021. The communication reads thus: F number 35/2021 IS-18 dated 10th June 2022. Your Lordship may kindly come to the next page. I am directed to refer to the judgment dated 28/10/2021 in writ petition civil 132 of 2016 titled as Rajneesh Kumar Pandey and others versus Union of India and others before the Honorable Supreme Court of India, wherein it directed central government to forthwith notify the terms and norms and standards of pupil-teacher ratio for special schools and also separate norms for special teachers who alone can impart education and training to children with special needs, CWSN, in general schools. The norms and standards of pupil-teacher ratio for special schools and also separate norms for special teachers who alone can impart education and training to general schools as recommended by Rehabilitation Council of India, Department of Empowerment of Persons with Disabilities, Government of India, have been accepted by this department and are detailed as under. Foundation levels, qualification, recruitment process, recommended PTR and remarks, Your Lordship. Foundation stage 1, preschool class 1 and 2, primary level, diploma in education in special education from a RCI approved institute and possess a valid RCI and CRR number, or thereafter preparatory stage class 3 to 5, which is again primary, DLED with a recognized qualification certificate diploma from a RCI approved institute equivalent to DED in special education and possess a CRR number, 6 months training program. And thereafter, Your Lordship, recruitment process through CTET, TET and NTA score plus demonstration of classroom teaching plus interview as per recruitment process and apted from time to time. So, Your Lordship, this notification specifically states that CTET, TET and NT all scores will be taken under consideration for primary level special education teachers, Your Lordship. Thereafter, Your Lordship, may kindly come to page 65. The highlighted portion of this communication be treated as directions given by this court to the states, union territories in terms of this order. At page 65, Your Lordship. Your Lordship, the notification that we are right now challenging.
No, you are not challenging.
We're not challenging that part. We are challenging the later part, Your Lordship, whereby they themselves have
Challenge
admitted.
to the rules.
The prayer doesn't say so.
Because if you come to page 68, I suppose that is the rule.
Your Lordship, 68 is for the secondary education, Your Lordship.
The primary?
Secondary education, Your Lordship, they have allowed.
Primary?
Primary is from 72, Your Lordship, page.
72. 18th March 2025.
And relevant qualification is at page 74.
June 22. 10 June 22.
Page 60 and 61, Your Lordship, of the Supreme Court order.
Yeah. Okay.
So, Your Lordship, in 3A, 3B, Your Lordship, they have allowed us to, they have allowed CTET to be a part of the qualifications for appearing as special teachers. And thereafter, Your Lordship will see at page 76, selection at 8, clause 810. They say thereafter selection of special education teachers shall be made on the basis of aggregate marks obtained in the following component. Only weightage of TET was given.
Oh. Seated has to be given.
Seated has to be given, Your Lordship. There's a contradiction in their rules in itself, Your Lordship.
In which state you have failed to qualify?
Your Lordship, petitioner number 1, Your Lordship, qualified in September 2015, CTET. Petitioner number.
Say that the petitioners have failed to qualify in TET.
In
which
TET,
year?
Your Lordship.
In which year they appear?
Is a recent date, Your Lordship, which is as per the notification of 6th February 2022, Your Lordship, 2026, Your Lordship, which is at page 81, Your Lordship. So 22nd February 2026 was the examination, Your Lordship.
Okay.
And we have rightly, we have not qualified, Your Lordship.
There was no, there was no requirement to appear if CTET was there.
Yes, Your Lordship, but the candidates in earnest wanted to appear for the TET exam as well.
Yes.
Lordship, first of all, Rajneesh, what my learned friend is showing the order of the Honorable Supreme Court, Rajneesh Pandey. According to that order, state government has taken steps for the special educators. Second of all, what has fallen for your Lordship? He has the degree of CTET. He never applied with that degree in the recruitment process. So the date is over. Applying date is over.
Applying date is not over, Your Lordship.
Lordship, tomorrow and day after tomorrow is the interview. The matter in the morning we did, Lordship adjourned it for tomorrow. Mr. Dasgupta was doing the matter for the special education.
Your Lordship, the notification for application came out on 12th March 2026, Your Lordship, which is at page 88, Your Lordship. It is here. So, Your Lordship, this notification in
First you have to
There is
apply, then the
first
verification.
a notification where you submit your application.
Yes, Your Lordship.
After it is verified, a notification is made that on such and such date, the persons who have received the interview call, they will appear on such date at such time for interview. So please don't confuse between the earlier notification and the subsequent notification for interview viva voce. This is probably of interview and viva voce.
Your Lordship, may kindly also see the
Interview
notification
and
once.
demonstration. Page 88, Lordship. Notification for verification, interview and demonstration of classroom teaching.
Your Lord,
The persons who have appeared,
at
Page 88, Lordship.
88, Your Lordship.
they have
Page
filed their application. no?
This is the notification, Your Lordship, for application, Your Lordship.
For verification, Lordship. Those who applied for
Not
demo.
for application. You see the notification at page 88.
Yes, Your Lordship.
After the words pertaining to recruitment, there is a bracket. And a reference of certain notifications has been given, which is dated 15 September 2025 and 12th November 2025.
Yes.
One is probably 15 September is the original notification,
Original notification.
calling for a person having certain eligibility criteria to apply.
Yes, Your Lordship.
12th November 2025 is a notification extending the time to furnish the
Yes, Your
application.
Yes,
Now that is closed.
Yes,
That
Your
is
Lordship.
closed for
That
you.
is closed, Your Lordship.
Now you intend to appear in interview.
Yes, Your Lordship.
So how can it be verified without the application being filed?
If Your Lordship, my Lord,
What for?
Your Lordship
So this is where-
understands these.
If you have a
these
better
people
case
did not understand
and
the
the
ramification
submission of
notification.
application is closed, how can you place your writ petition? Why it will be entertained for you only?
Your Lordship,
At the best,
I-
we learned
It is not that
in the next
in the
recruitment
month
process
of
special
November 2025, you had the option that time was
yes, Your Lordship,
extended.
we had the option.
So now you have missed the bus.
Your Lordship, since CTET was not mentioned there, we in right.
You have shown that street date is mentioned.
Yes.
You yourself have shown.
No, no. In the
That's why
notification
I
of
asked you, why did
15,
you appear for TET?
in the
When as per 10 June 2022,
I heard,
CTET was a qualification.
I understand, Your Lordship.
You appeared in TET
Yes, Your Lordship.
with the apprehension that CTET may not be considered.
Yes,
Now
Your
you
Lordship.
failed in CTET. Now in the month of March, you filed a writ petition asking that the CTET should be considered. It is not your case. CTET, it is not that the CTET has not been considered. It is there in the qualification.
But it has not been considered, Your
If you
Lordship, in
don't
the
apply and thereafter you file a writ petition, then how can
15 September 2025, Your Lordship, they have not mentioned CTET,
No.
Your Lordship.
Why should it be modified? The rule
In the
it says
recruitment
they will follow
notification, Your
rules of
Lordship, they have not
2025, which you have shown in page 74. It says that 10th June 2022 they will follow.
My Lord comes at page
No,
79, Your
sir.
Lordship.
Where is 15 September notification?
79, Your Lordship.
79.
Your Lordship, may kindly come at page 80, Your Lordship. Application modality.
Wait.
The schedule for obtaining
Sir, wait, sir. 15
Sorry.
September notification. What is the last date?
last date has not been given, Your Lordship.
Has to be there.
Your Lordship, the schedule for obtaining application form and submitted filled in application through online mode will be notified very shortly.
That is 12th.
Your Lordship,
12th November. Where is that?
that Your Lordship, we did not have, Your Lordship.
You have a copy? 12th November.
Your Lordship, may kindly come at next
12th
page.
November. Where is that notification? I need to go to that. You don't have, Mr. Chaudhary?
Right now, might not have.
Please that. Probably that is the date given.
That was the extension, Lordship.
Now, what is the date given in 15 September?
Your Lordship,
I mean,
may
application.
kindly appreciate one fact, Your
No,
Lordship.
no.
Your Lordship, the TET examination
You
for
need
special
certificate of
education
application form through
happened on 22nd, Your Lordship. Your Lordship,
Sir, try to
second,
understand one thing. That it is not that you didn't get the opportunity to apply. It is not that the
Your
rules does
Lordship,
not contain
application in itself is now.
rules. No, no, no. Again, I say,
State, Your Lordship, may kindly appreciate one fact, Your Lordship. 6th February 2026 was the notification for pertaining to conduct state for recruitment of special education teachers in primary school. Your Lordship,
12th November 2025 will clarify the situation. There has to be a last date. Otherwise, this will go on and on. How can this be? Can you get the copy? You have a soft
Your
copy
Lordship,
of that?
I'm just trying to find out, Your Lordship. Your Lordship, state examination was conducted, Your Lordship, on the 22nd of February 2026.
This he failed to qualify.
Which we failed to qualify, Your Lordship.
That is not the issue. Your case is that since you have qualified CTET, you should be allowed to appear. The obstruction or bar is that you have not made any application.
Yes, Your Lordship.
Either you came up before this court. It is also not the case that the board has not made that a qualification. Board has made that qualification in page 74.
Your Lordship, may I place the notification of this?
Give them. Give it.
No, see, date mentioned. Date mentioned. 25th November.
25th November 2015, 25 it is closed. Ashun. Can you get a copy of that? Give a copy of that.
I will, Your Lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities to consider the candidature of the petitioner for appointment to the post of special education teachers in primary school by considering the marks obtained by the petitioner in CTET, Central Teachers Eligibility Test, and also seeks for modification of notification dated 15th September 2025, 6th February 2026 and 12th March 2026. To that extent, the petitioners contain that they are, sorry, all of them possess D.Ed special education diplomas. Diploma in education, special education, diploma in special education, issued by the competent authority. The petitioners have also qualified. We can central teachers eligibility test bolo. In short, CTET. CTET for classes 1 to 5. CTET for classes 1 to 5. Dash primary stage. All the petitioners possess diploma in special, excepting petition number 7.
Your Lordship, I will just
Same-
submit that we
same-
tried applying, or after the notification of November, we tried applying, but it was rejected, Your Lordship.
Petitioner number 7 is undergoing.
No, no, I just got
hence
information.
have not
I
yet
just got
received the
information.
RCA certificate.
I
Is
just got
undergoing D8
information.
course and hence have not yet received the RCI certificate. Since the petitioners possessing CTET has not been allowed to
Not the case of lordship that they have not been allowed.
the petitioner claims that they should be allowed to take part in the interview/viva voce examination, which is scheduled to be held by the board on 24th March 2026 and 25th March 2026 on the basis of their CTET qualification. Mr. So-and-so, learned advocate appearing for the petitioner, submits that the CTET is a requisite qualification as per notification of the central government dated 10th June 2022. The petitioner intends to participate in the interview viva voce examination scheduled to be held on 24th March 2026 for recruitment of special education teachers in primary schools on the basis of CTET qualification. He informs that the petitioners have all appeared in TET examination. TET of which year?
2026, Your Lordship.
2025.
2026.
No. TET of which year? Exam might be conducted in month of February 2026. What is the TET of 2025? It will be 25.
Notification is also
2025.
2025.
But they have failed to qualify. He seeks for appropriate. Mr. Kaushik Chaudhary, learned advocate appearing for the West Bengal Board of Primary Education, submits that applications were invited from the eligible candidates. None of the petitioners
79.
None of the petitioners have made any application or tried to make application and sought for necessary permission from the court in the pursuant to the notification dated 15th September 2025. The submission of application through online mode has been closed on date
On 2nd December 2025.
no 25th
November. 25th November 2025.
Lordship, 25th November there was an extension. Lordship, may I hand over? I don't have the hard copy.
It was closed on.
This was the last extension. 2nd December.
2nd December 2025. Yes, 2nd December. 2nd December 2020. 2nd December 2025. As such, no right accrues in favor of the petitioner to press their prayers by way of the present writ petition. Admittedly, admittedly, a notification was published by the West Bengal Board of Primary Education on 15 September 2025, giving the requisite qualification. As per the notification, as per the rules, West Bengal Primary School Special Education Teachers Recruitment 2025, the qualification was as per 10th June 2022.
November notification.
Indicated in the said notification. Pursuant to such notification, which was extended from time to time and the last date for submission was valid till 2nd December 2025. Stop. No case has been made out by the petitioner that they were debarred from participating in the ongoing recruitment process initiated by the board. The petitioner has filed the writ petition after the closure of submission of application on 2nd December 2025. In view of the above, the writ petition falls short of merit. Dismissed. To be mentioned. 1 minute. What is the instruction? Mr. Banerjee, they are showing a document.
Due to some technical problem, what is my instruction? I am submitting on instruction. Due to some technical problems, it was not opened. It was accessible from today night itself. Because in respect of the request made by some of the teacher in charge of the other district too, and if they suffer any problem, they may contact the board to the technical assistant. He will assist them.
Okay. Matter is appearing under the heading to be mentioned. Mr. Joydeep Banerjee, learned advocate for courts.
This was the communication which I handed over to your Lordship, Milord, on the March 19, 2026.
This is the earlier representation, Milord.
No. Your answer by mail. Give me a copy.
You do one thing. Mr. Banerjee, I'm placing it tomorrow under to be mentioned to find out whether it is possible for the petitioner to access by using that password or not.
But
tomorrow
if
we
they
can
face
get
any problem, Milord, they may contact to the board and their technical assistant, Milord, will help them out. Kindly record it. I am telling Milord, I am submitting Milord on instruction.
So let us explore it today. Your
That is what
Lordship
I'm saying.
records that we shall explore it today. We have another issue.
It would be, Milord.
Yes, he is correct.
Today night.
Milord, it is not because of any other reason. Class 9, 10 form fill up is going on.
Exactly,
Milord.
Milord. Because of that reason.
For the convenience of the party, I place it tomorrow under the heading to be mentioned, recording your submission. Let them access that. If they face any problem, they will come back to this court and inform.
Yes. Milord, only another thing.
Milord, before approaching this court, Milord, they may contact to the concerned board.
And
Milord.
the board does not pick up.
No. They have specifically told that their Milord, the technical expert will assist them.
Every day this matter is coming up. Some glitch is coming up. They cannot access it. If access, then they cannot find how to register it.
They failed.
Please cooperate so that.
That's over the document.
That's why, Milord, it is better to contact the board.
Mr. Joydeep Banerjee, learned advocate for you are for the board.
I am for the board.
Board submits that.
State both.
State alada.
Submits that. The username and password will be validated by the concerned authority. In the event the petitioner face any problem, they may contact the concerned respondent. In view of the above, please this matter tomorrow. Acha, Mr. Vishwarup Bhattacharya, learned advocate for the petitioner, submits that from midnight onwards, the registration will begin. He seeks that the matter be placed tomorrow so that the picture is clarified. Please this matter tomorrow to be mentioned.
My lord, this is the opposition, my lord. As per your lordship.
Tomorrow, let it come up tomorrow. We'll come date for filing the opposition.
Advance copy of the same has already been served.
Kindly pardons us. Now, we have another issue which needs to be pointed out. Mr. Banerjee may come up. One teacher is retiring. I have been, telling your lordship, he's retiring in the month of April, his papers has to be processed, and for that, ID and password is also required. Kindly also, it is understood that Mr. Banerjee is going to come up with a response tomorrow, either from the end of the state or the board on this particular aspect.
We'll take a result one by one. Let it come up tomorrow.
As your lordship.
After that, we'll
As
see
your
regarding the pension matters.
Thereafter, my lord, it will come.
Great.
Copies have been served upon you.
Advance copy has already been served.
Should record tomorrow.
Yes.
Fix the date and date. Chalo. Raghu.
It will
Raghu.
My lord,
Great.
Deep leverage. কোনটা আছে?
Lordship.
আচ্ছা। এটা তুমি মেনশন একটু দেখে কি বলছে? এটা দুটোর সময় এটা আছে না? এইটা একটু শুনে নি কি বলছে।
This is for issuance of TET certificate with regard to TET 2014, my lord. Last occasion, my lord, your lordship, directed Mr. Bishas to take instruction, my lord. My lord, for petitioner number 11 to 15, I am seeking TET certificate. My lord, rest of the petitioners have already got that TET certificate during pendency of this matter.
Yes.
Director Civils.
আসুন।
It will take some time, but it will.
Okay. By the present petition, the petitioners have sought for issuance of certificate of TET, Teachers Eligibility Test 2014. Mr. Alambik, learned advocate for the petitioner, informs the court that the prayer for issuance of this certificate is only in respect of petition number 1115. Mr. Ratul Bisal, learned advocate appearing for on behalf of West Bengal Board of Primary Education, submits that the board shall take necessary steps for issuance of certificate of TET 2014 in favor of petition numbers 11 to 15. If the court issues such direction in view of such submissions, secretary will issue that. The secretary, West Bengal Board of Primary Education, respondent number
4.
4.
Sorry, my lord, 6. 6 is the secretary.
6 is directed to take appropriate steps for issuance of TET certificate of TET of 2014 in favor of the petitioner. Petition numbers 11 to 14 subject to their entitlement within a period of how long it will take, Mr. Vishwas?
8 weeks, your lordship give us.
Within a period of 8 weeks from date of communication of this order.
Deeply
it is disposed.
Yes.
Deeply.
দুটোর সময় কোনটা ছিল ওটা কি একটা তুই মেনশন কোনটা ছিল ওটা এদিকে Five.
My lordship, I am for the respondent in item number
5.
Yes, my lord. I am for the petitioner, my lord.
Seeking for an extension, my lordship, of 2 weeks to file the report.
There was a direction to file report or take
Yes,
instruction?
there was a direction, my lord. Through the
Mr.
submitted.
advocate appearing for the NIOS.
Yes,
NIOS seeks accommodation, seeks extension of time to file report. Let such report be filed within a period of 2 weeks. Is this matter after 2 weeks?
Either statutory not undertaking, then statutory.
Item number 697, 698.
6 হবে
Item number 5.
তুই কি আবার বলবি?
একটুখানি জাস্ট রিক্যাপ দিয়ে দিই 5 মিনিট
5 মিনিট
আর কি কনক্লুড হয়ে গেছে?
সময়টা নিয়ে নিচ্ছি।
Concludes his submissions.
My lord, there are 2 appeals. My lord, one is by the district primary school council against, my lord, the order by the appeal committee. My lord, I am giving just a recap. My lord, I completed my argument on the last occasion, but still, my lord, it's a long gap. My lord, I was working as a teacher, my lord, in a primary school. Now, my lord, thereafter, I was appointed as, my lord, the head teacher of that school, headmistress. Now, my lord, after I joined, within a year or so, my lord, allegedly, my lord, some teaching staff and some non-teaching staff, approximately, my lord, 6, my lord, they made a complaint that, my lord, in managing the school affairs, my lord, I am not working properly. What I am not doing?
Yes.
My lord, in purchasing
in purchasing, my lord, furniture of the school, I am not consulting them. In selling of, my lord, the things of the school, my lord, I am not consulting them. My lord, the collection of fees from, my lord, on account of development from the guardian of the students, these were, my lord, various allegations were made. Now, pursuant to that, my lord, there was a inquiry committee was sent, my lord, to the school, my lord, who inquired allegedly, and then, my lord, I was called before, my lord, the district primary school council. My lord, a purported hearing took place, my lord, in the question answer form that was recorded, and on the basis of that, my lord, charges were floated. Now, my lord, I answered the charges, disciplinary proceeding ensued, my lord. I was found to be guilty on all 12 charges. Now, my lord, the punishment, disciplinary authority, on the basis of the inquiry proceeding, disciplinary authority, my lord, imposed punishment with, my lord, stigma, no future. So, dismissal from the service with stigma. My lord, I preferred an appeal before the appeal committee. Appeal committee, my lord, deliberated, my lord, on all those charges categorically. Found, my lord, 6 of the charges, my lord, completely unfounded. My lord, turned those down. But those were set aside. So, for to that extent, my lord, the entire finding of the disciplinary authority was quashed. 6 charges out of that, my lord, said, my lord, that the evidence was not properly, though, my lord, it was found, my lord, those charges were also on the basis of conjecture and surmise. My lord, those 6 charges, lordship may kindly recollect, I placed, my lord, category wise, my lord, the charge wise, that, my lord, there, the conclusion was drawn by the appeal committee itself, my lord, that those were also based on either no evidence and on the basis of conjecture and surmises. Still, my lord, the appeal committee chose to remand, my lord, those 6 charges for the purpose before the, my lord, disciplinary authority. Now, my lord, this entire, my lord, order of the disciplinary, the appeal committee was challenged by, my lord, the district primary school council. They came before this honorable court, sought for a stay. Stay was not given, my lord, only status quo given. My lord, in the meantime, there in the appeal committee's order, my lord, it was given that, my lord, whatever is to be done, that is to be done within 3 months. My lord, that part, my lord, only for the purpose of refreshing the, my lord, memory. If your lordship kindly comes to, so take away my appeal, my lord, that I have given. That's, my lord, less voluminous one. Or, my lord, if that appeal is before your lordship, my lord, is the district primary school council, my lord, kindly take up, my lord, my opposition that I have given.
Yes.
Straightway to, my lord, the order passed by the appeal committee. My lord, that is starting from, my lord, 136. If your lordship is looking at my opposition, then, my lord, the operating portion is at page 159.
Yes.
158 it starts. Now, I'll request your lordship, my lord, to read from point number 21 at the top of page 158.
So this you have indicated.
Yes.
I have also marked it.
My lord, so there, my lord, those 6 charges, my lord, it is said that such inquiry, the instant appeal being 13 of 2018 is allowed on contest, and the order of dismissal of the appellant from service with a clause of disqualification for future employment as a teacher dated 12th April 2018 passed by the chairman DPSC Howrah stands set aside with a direction to cause a fresh departmental inquiry with respect to charges 1, 2, 4, 7, 10 and 11 of the charge sheet dated such and such in the light of the above observation against the appellant after giving her sufficient and reasonable opportunity of being heard, and to conclude such inquiry within 3 months from the date of communication of the judgment and order, treating the appellant as if she is under suspension. As if she is under suspension for an uninterrupted period since the date of order of suspension. So, my lord, my order of suspension is in the year of 2018. Since then, my lord, I am supposed to be deemed to be under suspension. Now, my lord, no suspension allowance, no subsistence allowance I am getting as. Let the matter pending before this honorable court. My lord, I finding, my lord, that I am not getting any financial benefit, my lord, relief. So because in the meantime, my lord, COVID also intervened, my lord, I preferred another appeal before the appeal committee. The appeal committee was not functioning because of this. And my lord, in the year 2025, appeal committee again took up that appeal and said that because of pendency of this writ petition, they can't do anything. So, my lord, I preferred a writ petition before your lordship. Challenging, my lord, the limited scope of my challenge is this part. My lord, I argued on the last occasion only on the limited point so far their writ is concerned on the maintainability, that judicial review, it cannot be like a second appeal. It's, my lord, only on the point limited to, as, my lord, it has been ordained in the judgment, my lord, I have relied on. And, my lord, specific point of law, my lord, rule 9, my lord, I have relied on. That, my lord, remand is not within the jurisdiction of the appeal committee. Either they reinstate or dismiss. And, my lord, the judgments, my lord, now, my lord, this is for them too. Then it's not a second, only on
How was it?
limited scope, my lord, disciplinary authority.
My endeavor would be before your lordships to show in our writ petition 9587 how the appellate authority went perverse. In coming to its decision. And, my lord, acted against, my lord, basic canons of law. I just take your lordship first to the, my lord, ঠিক আছে চলে যাস না কোথাও।
Yes.
My lord, page 7, your lordship, the charge sheet. I'm not sure, my lord, whether your lordship's copy is legible or not.
Page 7.
Page 7. Not 7, I'm sorry, my lord, page 59. Because this is a photocopy from other documents. In the font is 7, but your lordship's right hand side, top, page 59. My lord, there are, my lord, as good as 11 or 12 charges. My lord, let me proceed the best 231 on the basis of the, then I will, if necessary, I will take your lordship to that. Page 8, your lordship, charge number 3. Whereas it appears that you did not maintain any registers relating to setting up admission fees forms, setting admission forms, did not maintain any bill registers regards to printing of various bills for collection of fees, neither formed any committee relating to collection of admission fees from students on various heads, which is strictly beyond the rules, nor maintained any register for such collection of fund. This act caused serious misconduct on your part, is also unbecoming of the head teacher of the school. Petitioner, when the charge sheet was given, he was the head teacher. She was the head teacher. Paragraph, charge number 6. Whereas you have collected admission of fees on different heads since 2011 to 2013, namely at the rate of rupees 170, 180, rupees 190, 200, 220 for several classes from classes 1 to 4, by violating the norms without taking any such permission from the competent authority. You had collected all those amounts without maintaining any such register, thereby appeared to have you have committed serious misconduct by voluntarily violating the rules of primary education being a head teacher. Now, your lordships, I do not find, my lord, from the records, admittedly, she did not file any written statement of defense to the charge sheet. I will take your lordships to that subsequently. He went on making representations. Documents were not given, give me. He were given. He accepted then something. Then again said cash book photograph should be given or like that. Registers photocopy should be given. Well, it's not possible to give a voluminous documents. Ultimately, he was asked by the inquiry officer, you come to the office, you make it photocopies at your own cost and go there. Then she asked how much cost will be to be incurred. Then in this way, she went on delaying the matter, and ultimately the inquiry proceeded, and the inquiry officer filed the report holding the charges are proved. But I will, in respect of the other charges allegation, I will take your lordships to the report subsequently. But your lordships kindly come to the order of the removal, final order of removal. That's your lordships page. In this rate petition, I just give your lordships. Page 171 to 209. Your lordships will find from page 172 last paragraph till the page of 192. How many times the time was, your lordships can come to page 171, that the starting of the final order passed by the chairman of the council. From page 172, last paragraph, till the page of 192, your lordships, how he went on taking time that has been narrated. So application of mind is proved. Now, your lordships, I will take your lordships only to the charge number 3 and 6, how this has been dealt with, so that how the and the appellate authority how proceeded with this. I just take your lordships. Well, page 198, internal page 28 of the final order. 198. Handle korte oshubidha.
Yes.
The last paragraph, charges 3 and 6. PW3 deposed before the inquiry officer on 5th February 2016 that an amount of rupees 170 to rupees 200 approximately was taken from each student at the time of his or her admission to class 1. However, she had no idea as regards the total funds that was collected from the students as admission fees, since the matter of collection of admission fees was entirely within the domain of Srimati Rupa Mitra Chaki, the petitioner, with your lordships. PW3 further deposed the only thing that she was aware of was that Srimati Rupa Chaki used to intimate the respective class teachers about the students who had failed to deposit the admission fees, so that the said class teacher could request the respective guardians to deposit the admission fees at the earliest. PW4 deposed on 26 February 2016 before the inquiry officer that she had no idea regarding the admission fees that was taken from the students at the time of admission to class 1. PW5 deposed on 26 February 2016 that Srimati Rupa Mitra Chaki was entirely in control of the matter of collection of admission fees from the students, and that PW5 was not at all aware of the total fees that was collected by Srimati Rupa Mitra Chaki for such purpose. PW6, 7 and 8 also reiterated that Srimati Rupa Mitra Chaki used to take her own independent decisions as regards the admission fees that was collected from the students at the time of their admission to class 1. it thus transpires that there are corroborating evidences in the matter of realization and control of collection of admission fees by the charge-sheeted head teacher. The aforesaid depositions have not been opposed by Srimati Rupa Mitra Chaki, since he had chosen to remain absent to the inquiry proceedings and not to reply to the inquiry report to the dated 4th May 2016. A charge-sheeted employee must have an opportunity to deal with the inquiry report also. That was also given to her. He didn't reply. A complaint was lodged by the teachers on August 2013, 8th August, alleging every year an amount of rupees 200 approximately was taken from each student by Srimati Rupa Mitra Chaki, which totaled to rupees 1 lakh approximately for 500 students. Srimati Rupa Mitra Chaki used to withhold the result, diary, etc. of the students who failed to deposit such fees and return the same only upon deposition of the said fees. However, Sri Rupa Mitra Chaki never disclosed to the other teachers or to guardians as to how the total amount of the said fees was actually utilized by her. It was entirely within her own domain and never discussed anything with anyone. Srimati Rupa Mitra Chaki never maintained any register for selling of admission forms, badge, identity cards, etc., and never disclosed how much accounts were maintained by her. Moreover, Srimati Rupa Mitra Chaki herself has admitted in the hearing dated 18th August 2014 that there was no committee to look after collection of admission fees from the students, nor was there any separate register with regard to the fund collected or the bills issued towards the same or the admission forms that were sold to the students. Well, kindly see, not there was any separate register with regard to the fund collected or the bills issued. Even the bills didn't have towards the same and to the admission forms that were sold to the students. The Assistant Inspector of Schools, however, Howrah, also opined in his report dated 18th or 8th August 2013, Exhibit 13, that Srimati Rupa Mitra Chaki used to sell admission forms at the rupees 10 from each student, but no register was maintained by her. Srimati Rupa Mitra Chaki had informed the Assistant Inspector of Schools, Howrah, that 1,200 was collected from students, but no proper record could be shown by her. It was also found that rupees 10 was collected from the students for school badge, but no record was maintained regarding the same. Thus, it is evident that no register was maintained by Srimati Rupa Mitra Chaki relating to selling of admission forms, print or printing of various bills or collection of fees, nor was any committee formed relating to collection of admission fees from the students on various heads. Srimati Rupa Mitra Chaki, being the head teacher of the school, was duty bound to maintain proper register for the purpose of selling of admission forms, printing of bills, therefore collection of admission of fees from the students, and it was her duty to discuss the same with the other teachers and guardians by forming a committee. Therefore, she had no authority to take her own independent decision without discussing the same with anyone. Her act taking independent decisions regarding collection of admission fees from the students without maintaining any register or without holding any discussion with the teacher for the same constitute a serious misconduct, and I concur with the finding of the inquiry officers that the charges 3 and 6 proved. It is 201, 202. Now, your lordships, my lord, there is an appeal. I just take your lordships. That page 210.
Yes.
My lord, I take your lordships to the my lord, 211. Your lordships kindly consider
Yes.
page 213. That point I will subsequently show to your lordships. because that's I'm confining right now charges 3 and 6. My lord, page 218.
Yes.
Does the very first line, does the purported punishment is violative of Article 311? But he is not entitled to the protection of Article 311. He is not holding, my lord, any civil post. This is for the, my lord, government authorities, either central government or the central government offices employees. She is not entitled to. There cannot be any quarrel, I believe. Now, I will just, your lordships, kindly grounds. First grounds, your lordships will not find. In regard to room charge number 3 and 6, I just take your lordships kindly, my lord. I do not find any grounds regarding that. Charge number in regard to admission fees, correction, all that. My lord, kindly see only page 223, last paragraph. I will show subsequently. The appellant was not ground number 9, 223 page.
Yes.
Not the appellant was given any opportunity to cross-examine the witnesses.
Which line?
Page 223, ground number 9, last paragraph. This is required in respect of the entire disciplinary proceedings, though I am right now addressing your lordships, charge number 3 and 6. Now, your lordships, I just take your lordships through next paragraph and then your lordships 2 to 5 ends. I do not find, your lordships, any ground in regard to collection of admission fees or non-maintaining any register, whether she can at all collect any fees from the students, any grounds he has taken. She has not also denied that she has not collected. That is also evident from the order of the appellate authority, that she has collected. Then your losses will kindly come to page order of the appellate authority dated 9th January 2019, page 532. I just take your losses, the relevant portions in regard to the same. Decisions with reasons, page 538. Charges have been quoted, your lordships, in this first paragraph. I just take your lordships, the relevant paragraph only. Now kindly come to your lordships, page 544. Roman 3. With reference to charge number 3, it appears from the report that the inquiry officer authority held the charge as proved, relying on the hearing sheet dated 18th August 2014 and the hearing held by him. It appears from the charge sheet that the imputation was based on question number such and such. It is not clear neither from the report of the inquiry authority nor from the materials placed before us on behalf of the discipline as to whether the delinquent, being the head teacher, was obliged under any rule to act in the manner stated in the imputation. In absence of any rules, it is not open to the disciplinary authority to designate any act or omission as misconduct, and therefore, in our opinion, and the performance of any act which is not mandatory under any rule is not a misconduct, and the findings of the inquiry authority is board in law. The appellate authority is entering into a very big question. The misconduct cannot be defined, Supreme Court says. Even there are certain cases of misconduct enumerated in the rules. Misconduct can be beyond that also. It cannot be precisely stated by the rules that this is the misconduct, and other than there cannot be any misconduct. So, my lord, that's not required, but your lordships take note of that. This is one thing they have observed, and then your lordships will find very vital is page 546, Roman 6. With reference to the charge number 6, it appears from the report of the inquiry authority that he held the charge as proved, relying upon the hearing sheet dated 18th August 2014 and the hearing held by him. It appears from the charge sheet that the imputation was made basing the questions number 20 of Exhibit 1. On perusal of the materials placed before us, it appears that the delinquent admittedly collected fees on different heads from the students. Well, therefore, that's why it's submitted with your lordships that appellate authority also admitted that he collected the fees. There is no denial. Now it is to be ascertained she acted beyond authority or beyond rules by collecting those fees, and whether those fees come within the purview of expression admission fees as alleged in the charge sheet. Well, pause here for a moment. Our case is that you collected illegally and you did not maintain it registered. Now, if this is the finding that she acted beyond authority or not, the appellate authority, being a statutory authority, must confine to the records or whatever the parties have submitted. Well, that's why I have given you losses pain to go through the grounds and the appeal. Nothing there. There is no denial that he has not collected, nor this is a case that I was entitled to collect it under these provisions of law. So my endeavor to show now the appellate authority in an adversarial proceedings making a third party case. My lord, a court or an authority exercising judicial power cannot be a third party to the proceedings. He has to decide under the provisions of law, whatever, but he on the based on records. Now kindly see what he does, the appellate authority.
Yes.
But the next paragraph, it appears from the materials placed before us that the fees were taken on deferred heads like school maintenance, examination fees, annual sports, Saraswati Puja, diary, identity card, batch, miscellaneous heads, and amounts varies from. Well, conveniently, the appellate authority avoided the word admission fees. Based on what? Well, this is the records according. Let us proceed on that basis. Now, your lordships, the school in question is a recognized and aided school, and it comes within the purview of subclause 2 or clause N of section 2 of the Right of Children to Free and Compulsory Education Act 2009, and not a school established, owned or controlled by the appropriate government or local authority. I am putting a question to myself, but I will stand corrected by your lordships or by my learned friend. Would your lordships find any point was raised in regard to this status of the school? Because it now becomes vital for the chairman of council. This is being, writ petition is by the council. This was not. So, my lord, appellate authority on its own deciding a point of law based on facts. The status of the school is a mixed question of law and fact. So he ought to have invited the parties. If anything, suppose today we are arguing, some questions passes through your lordship's mind. Certainly your lordship put the question to both the parties and require an answer. What is your answer? It's court, your lordships can certainly do that. Even under section 165 of the Evidence Act, your lordships can put an irrelevant question to the witness also. So it is within the domain. If it is not a court, even it's judicial quasi-judicial functioning they are doing. So they must put a question. This is entirely wrong. I will show now, your lordships, how this is wrong. Right to Education Act. আছে রাইট টু এডুকেশন এক বাক্য এটা 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 তো প্রাইমারি হ্যাঁ জাস্ট দুটো কপি রাখতে হয় জাস্ট মিনিট আচ্ছা প্রাইমারির ওই বাইন্ডিংটার মধ্যে আছে না হ্যাঁ এটা জাস্ট দ্যাট ইজ মানে প্যানাসিয়া নাও
Yes.
Kindly come to right to the Children of Compulsory Education Act.
Page number?
Page in the index your lordships will get it. Just I'm sorry, Malad.
আরে ওই পেজটা কোথায় ওই ঘরে নিয়ে চলে গেছে নাকি দুপা পেজ কোথায় গেল রাখতে
33.
Yes.
Yes.
Now, your lordships kindly consider child means a male or female child of the age of 6 to 14 years. That's your lordships not required. Your lordships that will be required subsequently. But right now, your lordships kindly come to definition H, 2H, local authority.
Yes.
Local authority means a municipal corporation, a municipal council, or Jila Parishad, or Nagar Panchayat, or Panchayat, by whatever name called, and includes such other authority or body having administrative control over the school. This is vital, my lord. Includes such other authority or body having administrative control over the school, or empowered by or under any law for the time being in force to function as local authority in the city, town, or village. But I will take your lordships to the Primary Education Act, and I will show that all recognized primary schools throughout, my lord, in the state, in the primary school, my lord, under the councils, different councils. There are private schools, recognized primary schools. Within the jurisdiction of the councils, my lord, are all the schools maintained by the councils. They are the local authority. Then your lordships kindly see definition. The appellate authority mentioned it. School. School means any recognized school imparting elementary education. Under the Right to Education Act, there cannot be school without recognition. So every school must be recognized. Now, just because recognized, it cannot be a government school. So, what are the schools your lordships kindly see? And includes one, a school established, owned, or controlled by the appropriate government or local authority. The school now the petitioner was serving was the school maintained by the district primary school council, the local authority, is in red with section A, subsection H. It doesn't come, my lord, under Roman 2. All school maintained by the, my lord, council are under the grant in aid and pay package scheme of the government. What the appellate authority says, your lordships are recognized, and kindly see 2. And aided is a school receiving aid. This is not an aided school. All primary schools under the councils throughout the state are maintained by the council. Fees are paid by the teachers are paid by the council. It's maintained by the council, not maintained by any other body. Now, what did they do, my lord? Kindly see, an aided school receiving aid or grants to meet whole or part of its expenses from the appropriate government or the local authority. Appellate authority says it comes under 2. Absolutely wrong. It's a school. I will show the Primary Education Act. Primary Education Act 1973 ultimately given effect to sometime in 1990. The object is that, your lordships, under the act, that whole primary education should be brought under one umbrella, so that there cannot be any differentiation in primary education. There are private schools, those are different, those are recognized. There are maybe schools getting aids, minority institutions, they are getting aids, but they are not maintained by the council because exceptions are there because of Article 29 and 30. So this is a school maintained by the council. I will take your losses now to the Primary Education Act. Your losses also will be fine. এখানে আছে না? এটা নেই? তা আছে কোথাও? এখানে থাকার কথা। একটু প্রাইমারি একটা বই আছে দেখুন না, কোড। স্কুল কোড। এই যে আমার এখানে আছে, আমার এখানে আছে। ও জাস্ট বার করে দিন। We are giving. একটা দেবেন, একটাই দিয়েছি, মধ্যখানে কিছু দিয়ে দেওয়া গেল না।
In education manual, this act is there.
Yes,
I'm just giving you lots.
Volume 1 is.
এই এটা তো রুলস দিয়েছি একবার পর। এটা কি এক জজ সাহেব পেজ?
এই যে 167 পেজ।
Primary Education Act.
Education Act
1973 is there.
আচ্ছা, এটা নিয়ে তো
জজ সাহেবকে দেবো এটা? এটা দেবে?
Yes.
Kindly look at the object of the act. An act to make better provision for the development, expansion, management and control of primary education with a view to making it universal, free and compulsory. Primary education, to make it free. Primary means in our state 1 to 4, not 5 to 8. That comes within the elementary education up to 8. But there is a bifurcation up to primary education, it's up to class 4.
এখন অনেক জায়গায় ফাইল হয়ে যাচ্ছে আস্তে আস্তে।
সে তো ডিফারেন্ট স্টেটে আছে ফাইল।
এখন এখানেও হচ্ছে আমাদের ফাইল আস্তে আস্তে।
Now, your lordships, whereas it is expedient to make better provision for the development, expansion and management and control of primary education with a view to making it universal, free and compulsory. There is one language to bring it under one umbrella that I will show if necessary to your lordships. I
93 তে দেখুন, 93 টা এইটা দেখুন।
না এইটা Now, your lordships, kindly come to the act. The act is it. Kindly have a look at the school, primary school. Definition 2, Roman 18 here. Means a school or a departmental of a school set up under this act for imparting such primary education as the state government may prescribe and includes a primary school or a junior basic school recognized under this act and in existence on the date of coming into force of the West Bengal Primary Education Act 1996. Similar, by operation of law, the school becomes a primary school under this act, which was recognized and existence on this act, and it comes within the jurisdiction and authority of the council. Now,
Function of the council. একটু পরে আছে 37 এ আছে দেখুন।
No, 37. Just a minute, Malad. In the council, hold on. Malad, kindly consider page, section 60. It shall be the duty of every primary school council, A, to prepare and maintain in such manner and containing such particulars as may be prescribed a register showing all primary schools within its jurisdiction, as I submitted before office, together with the teachers thereof and the accommodation available therein. Therefore, by operation of law, whatever primary school recognized within the jurisdiction of each of the councils comes under the control and management of the council. Now let us proceed further, your losses will find it. To maintain in such manner and containing such particulars as may be prescribed a register of teaching or non-teaching staff of all primary schools under its management. To maintain in such matter and containing such particulars as may be prescribed a service record of teaching and non-teaching staff of all primary schools under its management. To tabulate such further information and to prepare such plans or maps as may be necessary to enable the primary school to frame an estimate of the existing provisions of primary education, of the further provisions necessary to place primary education within the reach of all children. Then to prepare in the prescribed manner schemes for extension of primary education and to make adequate provision for facilities for the free primary education to all children to whom such scheme applies. To arrange in the prescribed manner and with the approval of the board for opening of additional, that's not required, Malam, to provide for the welfare of the children attending primary schools and to maintain an adequate number of primary schools within its jurisdiction and to carry on propaganda for extension of primary teachers. Then you also K, subject to the prescribed conditions, to appoint teachers and other staff in primary school. Petitioner has been appointed by the council. And that's why the council has the authority to initiate disciplinary proceedings. It says it's an aided school. It's a school of the council. And because of consideration of law, wrong consideration of law, judgments comes wrong. It's absolutely our teacher. He says aided school. It's not an aided school. It's fully funded by the government and maintained by the local authority like council.
Yes.
Now your losses, again, my lord, I request your losses to kindly come to the page 546 of the judgment of the appellate authority.
Yes.
The school in question is a, just recognize that I placed before your losses. Now kindly see. In terms of GO number 187, AC law / S, has you lordship got one S? A stands for secondary. P stands for primary, either PRY or P. A stands for secondary. Why I'm saying it, I will just tell you. Dated 14th February 2011, it was made forbidden from collecting any fees or charge for the schools established, owned, or controlled by the state government or local authority. And it is further stipulated that no recognized aided schools or a school receiving aid or grants to meet whole or part of its expenses from the state government or any local authority shall collect any fee or charges or expenses from a child till completion of elementary education. Means, my lord, class up to 8, we are not concerned with. Other than a development charge up to maximum amount of rupees 240 only per year. The school in question is a recognized and aided school, it may collect. Kindly see, this is the finding of the appellate authority.
Yes.
Then, your lordships, admittedly, the delinquent being the head teacher collected fees ranging 170 to rupees 220. Therefore, amount was within the restricted range as stipulated in this head. Second finding. But I will show that this government order is not applicable to primary schools. It is also admitted that the said fees were collected on the basis of resolution adopted in the meeting of the Mother Teachers Association. Malad record says, Malad, none of the teachers signed it in both the resolution, except in one resolution, one teacher signed. But more, Malad, the serious question is that, does it give authority or jurisdiction to a head teacher who is the Malad, guiding person of the school to collect fees against the law? That I will show to your lordships. Mothers Teachers Association and the delinquent only implemented the decision collectively taken by the said association. Well, these sort of associations doesn't have any authority in law. There is no law doesn't recognize this sort of association. And since those resolutions were not disowned by the Mothers Teachers Association, Mothers Teachers Association was not a party to the proceedings and not required, I will show to your lordships. No responsibility can be fixed unilaterally on the delinquent. He is the head teacher, my lord. I will show that he cannot, my lord, collect a single noya paisa from a primary school students.
Yes.
She was the head teacher of the school. It is also an admitted position. The admission of any child was not refused. Well, they were forced. Nowadays, admission is very scarce. How could the one secure it? Then, moreover, kindly see, moreover, the term development fees was not defined in the aforesaid GEO, and the disciplinary authority has no right to interpret the same on his wish or whims without referring the question to the government. So it said that this is development fee, some is for batch fees, some for management fees, as stated in the earlier paragraph, if I'm not wrong, your lordships. The next earlier page, your lordships kindly see last but third paragraph.
Yes.
Defined kinds of a school maintenance, examination fees, annual fees, Saraswati Puja fees, identity fees. So says what one the appellate says, the development fees, what is that has not been defined. So you cannot say all these are not development fees. If you want to say that, you have to take the clarification. But I will show now that these government orders do not have any application to the cases of primary teachers. Now, your lordships, kindly take up this government order, my lord. 140. এটা তো আমাদের হাত দিয়ে আছে, এটা সবগুলি আছে, জাস্ট এ মিনিট, মানে রাইট টেক ইট। If any underline is there, my lord, kindly, this is a photocopy, kindly excuse me, my lord. Lord, kindly see the government of West Bengal School Education Department. My lord, had it been a primary, it would have been School Education Department primary. This is not primary, it's a secondary. I will show, my lord. Numbers, notification number S. My lord, your losses, as I pointed out. Now your losses kindly see. SE, matlab 187 SE, means secondary education. Your losses get it. Had it been primary education, PE.
Yes.
Whereas subsection 2 of section 3 of the Right of Children of Act in such and such provides no child shall be liable to pay any kind of fee or charges or expenses which may prevent him or her from pursuing or completing his or her elementary education. Then, whereas the governor has considered it necessary and expedient to do so, in exercise of the powers conferred by subsection 2 of section 35 of the Act, the government is pleased to hereby direct no government school established, owned or controlled by the state government or a local authority shall collect any fees, charges, expenses from child till completion of elementary education. Like because of wrong application of law in regard to definition of school. The first point, the appellate authority has applied it. Because kindly see clause A, if it is a school maintained and established by the government or by the local authority, maintained or anything established, owned or controlled, is a controlled by the local council. I have seen placed before lawsuits the sections of the Primary Education Act, more particularly section 60, and single no paisa can be collected. Now, kindly have a look with this before proceeding with the notification. Section 4 of the Right to Education Act. Right to Education Act. Probably losses will be getting in our bindings. Spiral binding.
At page
35.
Yes.
Section 4. I am on proviso.
Section 4. Yes.
For proviso. Dear lawsuits, kindly look at cursory glance in section 4, where a child has not been admitted in any school, or though admitted could not complete an education, he shall be admitted in a class appropriate to his or her age. Then proviso. Provided that a child so admitted to elementary education shall be entitled to free education till completion of elementary education, even after 14 years.
Yes.
Then your lordships, another section, I think the section 3 I ought to have placed it, subsection 1. Every child of the age of 6 to 14 years shall have a right to free and compulsory education in a till completion of elementary. Free and compulsory. This is, my lord, quoted in clause A by the governor. No government school established, owned or controlled by the state government or a local authority. A school maintained or controlled by local shall collect any fees or that. And then your losses kindly. Then B. No recognized aided school or school receiving aid or grants to meet the whole or part of its expenses from the state government or local authority shall not collect any fee or charges or expenses from a child till completion of elementary education other than a development charge up to a maximum of rupees 240 only per year. This clause was banked upon by the appellate authority. Therefore, determination of facts was necessary. The status of the school. How they jump to the conclusion this is a recognized school aided by the government. This is fully maintained by the government fund through the council, a local authority. This is the perversity. This is a mixed question of fact and law. You then ought to have asked question from us that you disclose the status of the school, whether this. And another point, your lordships, I will take further. This notification, who relied upon, my lord? I am putting a question to myself. Who relied upon before the affiliate authority? Myself. Or by the delinquent teacher? None. None relied upon. Now, suppose your lordships, on the other day also your lordships pointed out, in reply, Mr. Udronil, they wanted to cite some judgment. Then your lordships' reply was that then I have to give Mr. Sannal another opportunity to deal with this, then this will go on and like that. That's one aspect. Now, if court finds none of the parties, this is the adversarial proceedings, none of the parties do not rely a relevant judgment on the issue. Often happens. Now, the courts in this court's knowledge, honorable court's knowledge. Then it is the duty of the court to point out, you both of you consider and come back. This is the judge. Often happens. Now, if the appellate authority thought it fit that this would be applied, that it ought to have invited submissions from the parties. In the judgment they did it. That's why I have taken to your memorandum of appeal. Memorandum of appeal also do not rely upon this. Then who gave this? Then the appellate authority became a third party in the matter. And I have so many things to now point out before your lordships. Whether this is applicability or about the applicability itself. Because our school is only up to primary. Elementary education from 1 to 8. I am only up to class 1 to 4. And these, your lordships, in case of recognized aided schools, give this leverage to the authorities. Okay. Entirely, because kindly see now the proviso. That's why the appellate authority recorded nobody's admission was denied. It cannot be a ground because of the proviso. If somebody unable to pay such development due to organizations, his admission cannot be or his education cannot be denied. Doesn't arise up to primary education. And it's a school established by the government, maintained by the fund of the government through the council. It's a local authority. Even the definition of the local authority says. And the council is a statutory body, under section 30.
How do you say that this particular GO is not applicable in case of primary schools?
This
GO.
The present primary schools.
Yes.
Kindly see the A. No government school established, owned, or controlled by the state government or a local authority. Council is a local authority. Therefore, a government school or school maintained by the local authority. If your losses wants that now, the recognition memo have to bring it. That who may recognize it. It's a government. These sort of primary schools is established under the Panchavarshiki Porikalpana at the earlier stage. Phase by phase primary schools were established. How therefore it requires facts. You jumped up to the conclusion. I am saying, it's a school maintained by the local authority. That means council. Kindly have a look at section 61. I take your losses section 61. Teacher paid by me. Of course, through fund of the government. I do not have a single paisa, the council. Section 60 of the Act. It shall be the duty of every primary school council to
It is of which act? Section 6?
Section Primary Education Act.
Statutory body or body corporate.
I will show another provision that the council is a body corporate and statutory authority. Every body corporate is a statutory authority. Section 60, duties of the primary school council.
Yes.
Now kindly look at it, Lordships. It shall be the duty of every primary school council, A, to prepare and maintain in such manner and containing such particulars as may be prescribed, a register showing all primary school within its jurisdiction, together with the teachers thereof and the accommodation available therein. Now pause here for a moment. Admittedly, the council was paying the teacher petitioner.
Appointment letter.
And the appointment letter, your lordship, shows on the record, appointed by the council. How can it be a recognized aided school? Recognized aided school means private school, but recognized and aided by the government. That's an aided school. That's not maintained by a body. This is absolutely, then your lordships kindly look at subject to the prescribed conditions to appoint teachers, subrule K, to appoint teachers and other staff in primary schools, to transfer any such teacher or other staff from one primary school to another school. You'll also every day dealing with the transfer matters. This is our teachers. So this is a school maintained by the local authority, council. And kindly have a look, your lordships, with this, the definition of the local authority under the Right to Education Act. I placed it. Just your lordships kindly take, I have given a look. Huh? Oh, is it? You are saying it. No.
May I take your lordship's leave for a minute? May I take?
Other matters are fixed.
PPA matters নিতে হবে না?
Other matter may be released for.
না না আবার 3টের সময় ফিক্স আছে আরেকটা।
সেটাও স্যালারি আছে।
Yes, Mr. Ghosh, what are you saying?
I was taking leave below that, thinking that this matter will continue.
No, I have to stop because PPA matter is there.
No, I will take little time in this matter.
Or Mr. Subir Sanna, learned senior advocate appearing for the board. Due to paucity of time, the hearing could not be concluded. Release the matter on follow.
এটা আরেকটু ভালোভাবে গুছিয়ে জজ সাহেবের কাছে আনতে হবে। এর জন্য আমি এইটুকু টানালাম।
15 দিনের মাথায় 15 দিন 3 সপ্তাহের মাথায় একটু দাও 3 weeks
বাকিগুলো এগ্রিমেন্ট দেওয়া হয় আমি বলেছিলাম না সব আলাদা আলাদা করে দিয়ে দেবো তারপরে আমি হয়ে গেলে
না 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 তুমি ইয়েতে যাও না আবার ইলেকশন মোডে চলে যাবে 25 তারিখ দিয়ে 25 এপ্রিল
প্রথমটার সঙ্গে দ্বিতীয়টাকে দেখিয়ে দিতে হবে দেখিয়ে দেবো তুই ওইটা নিয়ে
সেকেন্ড হবে
সব নাকি
24
দিদিকে বল দেখবার
24th April.
My Lord, one humble prayer, my Lord. It was, my Lord, submitted on the last occasion. My Lord was pleased to grant that, but it appears, my Lord, it has not gone down in the order. But pattern.
Not also can do it.
It has not. If I am not wrong, my Lord, we got a printout, my Lord, from the website, my Lord, we couldn't, Sarva copy, we couldn't get it.
Okay.
হ্যাঁ ঠিক আছে ওকে ওই ভালনারেবল উইকটাই নয় পয়লা বৈশাখের উইকটা নয়
হিয়ারিং অন
হ্যাঁ
25th April
24th April your lordship
24th yes 24th April
It's probably not there.
এটা কি
Yes, I have indicated.
Grateful.
2 p.m. তোমার
2 p.m.
I will on this my lord I will my lord, prepare a short note so that your losses can deal with that.
Okay, that will be fine.
On the status of the school. Status of the local primary school.
এটা একটা ফাইল দিলাম
এবার কি হয়? কি হবে?
এই 25 আছে তো।
26, my lord. I am for the petition. It was that error, my lord, printing error matter, my lord. On the last occasion, the board submitted that they will file a short opposition regarding that. But I have not received any opposition.
No, my lord, we filed our, we have filed
No,
our
not in our matter.
No, my lord, I tell your lordships. Lordships might remember, I submitted with your lordships, I will use a composite affidavit.
Then I have not been served.
It was also understood that it will be given to my learned friend, and my learned friend will circulate it amongst themselves. Because I am using one composite, but then I can give them also. That was the understanding.
I have not received.
ঠিক আছে আমি দিয়ে
দিয়ে দেওয়ার কথা।
আমি দিয়ে দেবো
The only one I have, and they have not used affidavit to that.
No, we
Reply.
have.
No.
কবে? দাও, কপি দেখাও।
দেখো
দাও।
বলেছিলাম ওটা কোনটা?
দিতে চাইছি আমরা
কোনটা?
কোথায় না না না
আজকে দিতে চাইছি।
ফ্রাইডে
No, no.
ফ্রাইডেতে তুমি যখন ফোন করেছো ব্রাদার আমরা ক্লার্ক
Which one is your matter?
5টার সময়
My matter is
দিয়ে
item
গেছে।
25
আমি
and
যদিও আমি অনলাইনও দিয়ে দিচ্ছি আমার কাছে ম্যানুয়াল
অনলাইনে
my point is only limited to that there has been an admitted printing error and I should be awarded marks for the same.
এটা কত
My lord,
থেকে
if
শুরু
they have
করছিস?
used a common affidavit, a copy may be given so that I can deal with.
Now I will
Six
give
order.
them a copy since they have not given. এটা কি? My learned friend is now giving reply.
Milord, I have Milord served them on Friday, Milord. I have served them, Milord, scan copy, Milord, online, Milord.
If not, my lord,
No,
kindly
where
see
is
the-
your opposition in the
That
item
is
number
multiple
26?
copies,
মে আই ফাইল
If Milord can. Yes. This is the reply, Milord.
এর দুটোরই কপি ওকে দে। দিতে হবে। না, আমাকে দিন। ওপরে একই হবে।
You are in which item?
27 and 28.
সাতাশটাকে আমরা ইয়ে করছি সীমান্ত
আরে
Seven to the-
পয়েন্টটা না এখানেও নিয়েছে ওরা। ওর পয়েন্টটা। ও পয়েন্টটা এখানেও নিয়েছে। তুই বললো কি বললো তুই নেই? না মারা যায়। 10:30 আমি এক সপ্তাহ করে দেবো। তুই এতদিন
4 দিন ধরে করবো
10:30 তোরটা পোষাবে।
আব্দুল্লাহ তাহলে একটা কপি দাও আমার।
দিয়ে দিচ্ছি বাবু এখন কি করে দেবো তোকে
ও
লক্ষ্মী পুজো হোক
তাহলে তো এটাতে ফাইল করবে একটা হবে। এটা তো সিমিলার ডিরেকশন দিয়েছিল। যাই হোক এটাতে ইউজ করবেন না, তো রিপ্লাই দিতে পারবেন না নাহলে। আচ্ছা আসুন। অ্যাফিডেভিট ইন অপোজিশন। হ্যাঁ করো অ্যাফিডেভিট ইন অপোজিশন। এটা 29066 of 2025, item number 27. Affidavit in opposition filed by the board is taken on record.
এই রেকর্ড করছি সব দিচ্ছি।
Where is the reply?
Yes.
Affidavit in reply filed by the petitioner is taken on record.
My lord, we are just now we are receiving, let me go through it. হ্যাঁ, তো কি দেয়নি তো কম। কি দিয়ে? আবার ডকুমেন্টস দিচ্ছি।
Suvi Sandal, a senior advocate, appearing for the board,
মমতা
submits that
দে উত্তর দে।
the board will not file separate affidavit in oppositions in respect of other petitions, namely WPA 29805 of 2025, 27 এর order হচ্ছে না, 28174 of 2025, এইখান থেকে একেবারে
এখানে আমার কোনো আপত্তি নেই, আপনি নম্বর।
from item number 25 to
25 and 26 is mine and
item number 25 to which is the item are similar? 32.
31
Milord, 27 and 28 was been heard, Milord.
ঠিক আছে, একই জিনিস।
And Milord, in 25.
Wait.
ও দুটোই আগে শুনবি।
30 2 31 31টা এক করে দেবে, ঠিক আছে? ফাইল করছে না। Copy of the affidavit in opposition filed in WPA number 929066 of 2025 be served upon the learned advocates for petitioners in other writ petitions. Aforementioned writ petitions. You will be filing any reply? Okay. Liberty is granted to learned advocate for the petitioners to file affidavit in reply to the opposition of the board filed in the other writ petition, namely WPA 29066 of 2025. ঠিক আছে? আমরা একসাথে করে দিলেই তো হয়। Mr. Chanal and Mr. Can we take it up analogously? Yes. Or the facts are different?
Well, only one thing. Well,
I have argued.
but that
He also contested that. And affidavit has been filed on that matter. So it's easier for all of us to take up.
No, because can we take it up analogously?
yes. Because I think Mr. Dasgupta's point only one question. This writ petition also deals with that and that. So that should be the
with করে দাও with তো আজকে তো নেই with, ঠিক আছে? পরের দিন থেকে
একটু আলাদা কিছু হবে হয়তো দুটো মানে ডকুমেন্টস কোথা থেকে
reply. When can you come up with the reply?
My lord, I can file within 7 days.
এই দেখ এনে পড়
But my lord, from the date I received the copy of the opposition, I have not received it.
Serve a copy of the opposition to the other.
Yes, I will give to Mr. Dasgupta.
আমি দিয়ে দেবো আজ দিয়ে দেবো
হ্যাঁ, shall be served upon the learned advocate for the petitioners in the course of the day.
কোথায় দেখ কোথায় গেলি
মানে ভাই টুডে কোর্স অফ দ্য ডে বানালাই
Okay. Then release this matter on Monday বা ওই উইকে ফ্রাইডে 17
কোথায় গেল প্যারাগ্রাফ পেজটা অনেকগুলো পেজ এরকম তোকে বলেছি মেল করেছি আমি না ওরা করেছি
ওই একই জিনিস
17th April
চিঠি ওকে
দেখো 2 PM কিছু আগে করে
বিশ্বাস করে
2 PM ইন্ডিকেট করো আন্ডার দি হেডিং হিয়ার।
ঠিক আছে মানে কটা কি বার পয়লা বৈশাখের পরের দিন বোধহয়
Okay.
মানে kindly keep the next a week your losses
On 17th it will come.
no mine no
Foreign country, can you?
17th April.
17th, maybe in foreign
Mala no Mala I never go for Mala 17 is little vulnerable for me any Mala next week
the long weekend.
that's your losses 2 I'm always
17th তারপরে 20th এ করো।
yes
20th
20
yeah
all
20 তে সেকেন্ড হাফটা দেখো।
ইলেকশন নেই তো দাঁড়াছে তো
আমরা তো সবসময় দাঁড়িয়ে থাকি যদি ইলেকশনের আলাদা দাঁড়াই অনেকজন দাঁড়িয়েছে
রুল
না না কোথায়
তারপরে হবে
না না না
দুটো বিজেপি কে
করে দিন না।
অরিজিৎ আছে
অরিজিৎ আছে পার্থ ঘোষ আছে
হ্যাঁ ও তো রানীগঞ্জ
চারটে
অরিজিৎ আছে
দেখে নাও
তৃণমূলের শীর্ষন্য দাঁড়িয়েছে শ্যামাপ্রসন্ন লোহার
সবাই আছে কিনা। Mr. Dasgupta,
Yes, ma'am.
আমাদের বাড়ির
all the petitioners are represented by you in the other matters.
25, 26, all are being represented.
In 27, Mr.
this poor man is there.
28.
Yes, my lord. In 28.
এটা কি
28.
Yes, my lord. Our.
Okay. 29 is your. 30 is your. And 31. Oh.
তিনটে তো
The petitioners in aforementioned writ petition to file their respective affidavit in reply.
এগুলো হচ্ছে ইয়ে
চল
I have not disturbed, my lord. Now, okay, allow me to disturb yours.
not today.
No, I have to disturb to some extent.
Why?
Right, my lord. Subsequently, there should be any problem. In the affidavit in opposition, they have taken a point that the writ petition, the documents are not legible. They have supplied in the reply, those documents are also annexed. And if they want, I can supply here and now another copy. So subsequently, there should not be a problem, and in the midst of the hearing, it should not be stopped. The specific amendment in the affidavit.
This is the reply.
I've seen that.
These are no grounds. Give a legible copy to. This has to be recorded.
No, in the affidavit they have said.
Affidavit, I have said some of the documents I am not in a position to deal with that because it's not legible.
That's
Because
why,
communication was made to them.
This one, because now it's supplied, it will be changed, no problem. But
Listen, again, same thing.
Well, Mr. Sannal, then again he files a legible copy to you, give a legible copy, then you have to again deal with the.
But if not necessary, I will not.
No, I will
And
not.
if not necessary, I will not. If necessary, I will in the meantime, I will deal with that. So that they can deal with it.
Then give a legible copy.
That has
So,
supply.
okay.
Oh, it change করে দে.
Read how he can read. We are the same age. Not possible.
So many pages are not legible. Then this is not out of the record. They will change
You
it.
change it.
Fresh copy though. Please understood. They will give us a fresh copy.
ও না আগে একটা মামলা আছে
এই দাঁড়ান 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 5% আছে দিব্যেন্দুর আছে
Yes. My lord, item number 39 and 40, my lord. In 39, I am appearing.
40?
And in 40, my lord, Mr. Chatterjee, Dibyendu Chatterjee is appearing. In both the matters, my lord, on the last occasion, it was submitted that they will file their opposition. And they have not filed, my lord. In item 40, I have been told they have filed an opposition. But in item 39, they have not. If they rely on the same opposition again, my lord, then kindly serve so that I can reply. In this way, my lord, the matter is being dragged. Thrice, my lord, time has been frayed, my lord.
My lord, in one of the matters,
এটাই আমরা করছিলাম
this was being moved before your lordships. We have used our affidavit. Shobboshachi Sap.
Item 40.
40. And the other matters, my lord, we have not because factually all are different, I find. So this matter, my learned friends matter, তোর matter ওই কি যারা আগে প্যানেলে ছিল তাদের এরকম না
না ওটা হচ্ছে চিত্তরেরটা
তাহলে এটার কি আছে
এটা ওর সঙ্গে চলছিল যে এইটা করেছিলাম যে ওইটা হয়ে যাবে
তা হবে নাকি এটা তো হচ্ছে
কয়েকটা প্যারাগ্রাফে দিব আদারওয়াইজ সুদীপ্তদেরটা
give me little extension so that I can deal with that also. I have. This is ready. This has been served.
This matter is required to be heard
Together. You do that, you know. Do together.
ওরা রিপ্লাইও দিয়ে দিয়েছে
কারা হ্যাঁ ওরা reply
So, is it necessary for the board to file another opposition to the writ petition?
Exactly, that's I'm considering. If not, I will give little extension, your lordships. If required, I will give. Otherwise, I
File
will.
your affidavit in opposition to the other writ petition?
That may be recorded, your lordships.
Affidavit in opposition filed by the board in WPA 30939 of 2024.
দিব্যেন্দু নামটা দিয়ে দে
Taken on record. Who is for the petition in this?
দিব্যেন্দু চ্যাটার্জি is appearing.
Dibyendu Chatterjee.
কেউ আছে? None appears for the petitioner. Mr. Acha. To be Sannal and senior advocate appearing for the board in WPA 2661 of 2025 seeks extension of time to file affidavit.
In
said
my
writ petition. Affidavit in opposition said writ petition. Get such affidavit in opposition. Reply.
In item number 41, I am for the petitioner.
ওই আগেরটা যেটা করলো না affidavit in opposition তার নিচেতে affidavit in reply filed by the petitioner is taken on record.
Yes, yes. I'll file.
এটা কমপ্লিট হলো হিয়ারিং এর ডেট রেখে রাখুন হ্যাঁ 2 weeks হ্যাঁ 2 weeks
আমাকে হাওড়ার দিদিকে ধরিয়ে দে
রিপ্লাই 1 week 3 weeks পরে রেখে দাও কি হলো সুদীপ্ত কি বললো?
আমাদের জন্য টাইম নেবে সময়
এটা কি
ফ্যাকচুয়ালি কিছু ডিফারেন্ট আছে।
কবে হচ্ছে হিয়ারিং এর ইয়ে 13 আবার 13 আবার 13
13 ঠিক আছে। না 17তে দিবেন না প্লিজ। 13th আমার কোনো অসুবিধা নেই। তো কি হয়েছে? ও
13
কবে?
দেবো? 3টের সময় দিয়ে দাও।
Let by affidavit in reply be.
কবে দিলেন?
Give your affidavit. 13
13 3 p.m.
My lord, in the meantime, in item 39, let them file their opposition so that I can also.
Yes, that's why it's 2 weeks have been given to them. 1 week for you to file a reply. Hearing আসো
After 13 any day.
দিস তো কেউ নেবে না মালা দিস উইক।
After 13 any day, my lord.
কেউ করবে না।
coming week 22nd 23rd
Joseph have the calendar.
ও আচ্ছা
আসবেও না।
কেউ আসবে না।
21st এ দেখো 21st নয় 22nd বা 23rd এ
আমি দিয়ে দেবো আন্ডারস্ট্যান্ডিং ছেদে না আমার উপর।
23rd এ দিয়ে
তোমাকে তো মনে কর
23rd to April 24th এ দিয়ে
ওদের গুতিয়ে না দিলে হবে না। কতগুলো
একটা হলো না
অ্যাকচুয়াল থাকে সেগুলো ইনস্ট্রাকশন ছাড়া অথরিটি হয় দেবে কি?
24th এর পরে এটা রাখো
আমাকে একটু মনে করাস।
3টের সময় রাখো আগে এগুলো কমপ্লিট করো।
In my matter, affidavit ready for hearing.
বলে দিয়েছি চ
24th 3 p.m.
অল রাইট। এটা কি নাম্বার ছিল জানো? 5% নাকি?
হিয়ারিং এর লিস্টে নিয়ে যাবে মোশন নয়।
24 কটা? আবার তার সঙ্গেই লেগে যাচ্ছে। কটার সময় রাখলো? 24 তারিখ।
Where is Mr. Saha? He has filed the report.
3 p.m.
I have not received any report.
What is this case?
Well, this is the difference of grade pay. Well, the senior are getting the less grade pay than the junior.
Oh, that is the only grievance.
My lord,
That is the only grievance.
that is the only grievance.
But then, why this has happened?
Because at the time of fixation of the ROPA 2019, they have 18 years benefit has been cut. As a result, those who are subsequently completed their 18-year service, they have been fixed at grade pay 3,900. Whereas my grade pay, I have been senior, my grade pay has been fixed at 3,600. On the other side also,
He is there.
Contempt is there.
Then it's passed over. Call him.
Then make it not doable. I again next week.
Next week. So none appears on behalf of DPSC Paschim Mednipur, nor any report has been filed pursuant to order dated 17th March 2025.
But to my lord, director, I have communicated order to people the
17th March 2025. Oh, where is your report?
My lord, I shall come with the report, my lord. But in this matter, my lord, I have to have talked with the my lord, my chairman. My lord, in this matter, my lord, the state is the appropriate authority, my lord. And my lord, in another matter, who's the my lord? Yeah, that matter. But
they are claiming
in
2006.
ঠিক আছে a report be filed, my lord. We shall file order, my lord, in respect of
Already, Lord,
ওটা stated দিতে
2025 that's the direction. Initial order is 2025.
Yes. I shall come with the my lord report, but it is to be, my lord, by the state respondents.
Colonel Advocate DPSC Paschim seeks extension of time to file reports. Let such report be filed within 2 weeks. This is matter of 2 weeks.
Again,
Yes.
Next week ছুটি।
ঠিক আছে।
Because this cannot be resolved without the report of the board.
My lord,
Come up with the report.
my lord, because of and my lord, this report, my lord, it
There
is
is a report by the chief secretary.
yes. In another matter, chief secretary, my lord, used a report.
That I am entitled to take it.
If they are entitled to, you come up with the report. How
Lordship,
can this be
Lordship,
resolved? It says that junior have been
Lordship,
given.
Lordship.
Ah,
Deeply obliged.
next.
My lord, I am paying cash for reply, my lord. Actually, my lord, the petitioner suffering from pox, my lord. So she could not come to the court. So, my lord, I'm seeking 10 days time on it.
কোনটায় ওইটাতে আমি নাই
Sure. Accommodation is sought for. Hey, Asun. Dismissal learned advocate for the petitioner seeks extension of time to file affidavit in reply. Let such affidavit in reply be filed within 2 weeks. মেনশনিং করে লিস্টে নিয়ে আসে তারপরে যে টাইম শুরু হয় yes next
Great.
My lord, here, my lord, the case of the petitioner is a TET qualified candidate. Petitioner participated in the 2020 recruitment process. Petitioner was recommended but wrongly recommended because at that time petitioner did not completed the training qualification. Petitioner was although recommended, but at that relevant time petitioner was not appointed, and rightly so, petitioner did not possess the training qualification. Be that as it may, my lord, when the 2022 recruitment process was initiated, I completed my training, I participated, I was called for interview, but at the interview stage, my interview was not taken on the ground that you are impaneled of 2020 recruitment process, and there was an order of the High Court that in-service candidates will not be allowed to sit in the 2022 recruitment process. And that is why, my lord, my candidature was not considered. Immediately, I gave representation. Even the DPSC, my lord, wrote to the board that say this candidate is not an impaneled, kindly advise us what to do. My lord, it is pending till now. So what I want, my lord, that I am not an impaneled candidate. It was wrongly recommended. It was ultimately cancelled. So I ought to have been considered in the 2022 recruitment process.
Where is the order of the honorable?
My lord, this is at page 27.
No, the order passed by this honorable court that 2020 who have been impaneled, they will not be allowed for 22.
My lord, that is not annex, but my lord, admittedly, this is the scenario that 2022, no in-service candidate would be allowed to participate.
Board was restrained not to give any appointment of the in-service teacher.
But I say I was not an in-service.
Board was under the impression that all the 32,000 appointment will further will give them appointment in the another recruitment process so that they can save their service. On the aspect, court passed an interim order directing not to appoint any in-service.
I do not fall under.
None of us appealed against it, my lord.
No, if the recommendation of the petitioner in the earlier process 2020 is a wrong recommendation, then he is not an impaneled candidate.
Yes, my lord. That is my case. Let them
file the report, your lordship, my lord, kindly consider, and my lord, pass the order.
Where is that report?
My lord, I have also taken the exception.
What is in the report?
My lord, report is very, my lord, 2 pages report, my lord, just.
My lord, this is the report your lordship has got that.
Yes.
এটা দেখান এই জিনিসটা।
This is the report.
This is the report, and I have taken also exceptions.
এটা দিয়ে দাও। No, what is the stance taken by the board?
My lord, the only stand taken by the board is, my lord, that I have approached this honorable court after the recruitment process is over, but my lord, it is not yet over. Admittedly, not yet over because
Absolutely, the after recruitment process, whatever now we are giving appointment or doing is in the pursuant to the order.
that means the panel
court.
survives, my lord.
As per the law, panel, my lord, expired.
My lord, if the panel has expired, even the court cannot extend the validity of the panel. The panel is continuing. That is why the court has said that you give appointment. If a panel is an incomplete panel, they publish
That
some.
matter was pending. The court, my lord.
Yes,
was
that is why the
matter
panel is not exhausted.
Panel exhausted.
And my lord, if the fault is entirely upon the authorities, my lord, I cannot be made to suffer for their mistake.
Para 6 is wrong. Para 6, it starts as petitioner's impaneled candidate.
Yes.
But that has been withdrawn.
Yes.
Impanel candidate, ultimately appointment was not given.
Yes. Then how can I be impaneled?
6 and 7 is my lord, our stand. And 7 is my lord, ultimately stand, my lord, because
What is your prayer in the writ petition?
My lord, this is at page 13, my lord. My prayer is page 11. Your petitioner and regular candidate in one of them to consider the candidature of the petitioner in the 2022 recruitment process.
You were successful in the 2022?
Yes, my lord.
Success?
My interview, my lord, my interview was taken. But ultimately it was not considered that since I am an...
Oh.
now, my lord, the score has to be, the board has to, my lord, calculate its score. If it comes,
Yes, definitely. I cannot say that if I secure less marks, I will be considered. Let my candidature be assessed, and if I come within the merit, my lord, I may be appointed.
Got to have come, my lord, before that. That is, my lord, only paragraph 17. If your lordship, my lord, ultimately allows, but it will not be a precedent, so that, my lord. Otherwise, my lord, floodgate will open now, my lord. After expiry of, my lord.
What floodgate?
2025, yes, this is the floodgate. Then, my lord, is not entitled. Otherwise, Supreme Court says, my lord.
Supreme Court says, and the panel is ongoing.
We cannot, my lord, submit together. My lord, in the Ali Hussain Mondal, Supreme Court has said, my lord, the panel has expired, my lord, after, my lord, 1 year. That's of 1 year.
That is in
case, my lord, the 1 year has, my lord,
then
lapsed.
how can they are giving appointment, my lord, after again expiry? No, because the panel was incomplete. A panel has to be in its appropriate form in terms of the rules. The panel itself was incomplete.
By the present writ petition, the petitioner seeks direction upon the respondent authorities to consider the candidature of the petitioner in respect of primary teacher recruitment process of the year 2022. Petitioner contains that he participated in a recruitment process of the year 2020 and 2020.
Yes, my lord.
Pursuant to notification dated 23rd December 2020 for stop. The petitioner's name was recommended by the West Bengal Board of Primary Education for the post of assistant teacher in Jhakirpur, Santhal FP School, Post Kumarganj, Kumarganj North Circle, District Dakshin Dinajpur. PD memo number 465 within bracket 21 dated 17th February 2021. Which paragraph you have stated that such appointment was withdrawn subsequently?
Just give
yes. The respondent authority subsequently withdrew and cancelled.
Paragraph 6, my lord.
Yes. Withdrew and cancelled the letter of appointment of your petitioner, stating that at the time of application he had not completed the training. Thereafter, the petitioner has completed the training.
Yes, my lord.
In the year
2021.
The petitioner has completed the requisite training in the year 2021. Stop. The petitioner participated in the primary teacher recruitment process of 2022 and secured a total marks of 24.133 excluding viva voce. The petitioner was called for interview.
Yes.
Called for interview. However, the petitioner was not impaneled in view of the order passed by a coordinate bench of this. This is a coordinate bench of this court in WPA 24562 of 2022. Moni Deepa Purkait and others versus State of West Bengal and others, directing the board to preclude the in-service candidates from appearing in the interview of 2022 recruitment process. The petitioner has been wrongly considered as an in-service candidate. Being agreed by such action of the respondent, the petitioner has filed the present writ petition. Mr. Sudipto Dasgupta, learned advocate for the petitioner, submits that although letter of recommendation was issued for appointment of the petitioner as assistant teacher in a primary school by the board, but subsequently that was withdrawn, in respect of recruitment process of 2020. However, subsequently that was withdrawn since at that point of time the petitioner 2020 that was subsequently withdrawn since the petitioner at that point of time was not possessing the requisite training qualification. After completing training in the year 2021, the petitioner again participated in recruitment process of 2022. The petitioner was called for interview. However, he was not impaneled since he was wrongly considered as an in-service candidate. He seeks for appropriate direction upon the respondent board to consider the candidature of the petitioner in respect of recruitment process of 2022. Mr. Ratul Biswas, learned advocate appearing for the board on the contrary, submits that the process of recruitment in respect of the year 2022 has already been concluded. As such, the prayer of the petitioner cannot be considered at this stage. Mr. Dasgupta, in reply, submits that due to fault on the part of the respondent authorities, the candidature of the petitioner was not considered. Stop. It is not in dispute that in respect of recruitment process of 2020, letter of recommendation was issued in favor of the petitioner for appointment as assistant teacher in a primary school under DPSC Dokhin Dinajpur. However, the appointment was subsequently withdrawn. As such, the petitioner cannot be considered as in-service candidates to be precluded in terms of order passed by this court in WPA 24562 of 2022. Accordingly, the respondent number, who is it to consider? Secretary.
Board respondent number.
Number 2.
Number
West Bengal.
3.
Not 3 laws.
2 and 4.
Respond number 2 and 2, West Bengal Board of Primary Education and its secretary is directed to consider the candidature of the petitioner for the recruitment process of 2022 in accordance with law within a period of within a period of 8 weeks from date of communication of this order. It is made clear that this order is restricted to the petitioner only and shall not be treated as a precedent, disposed of.
The only thing, my training was of 2019 and 21. My mark sheet issued on July 2022. It should not be 20.
Session of 1921.
21 and mark sheet of July 2022.
Paragraph number.
At page 17.
Paragraph number?
No, page 17 if your lordship kindly sees.
Page 17. Okay. 2019 session.
Allowed the petitioner to participate in the process, right?
No, I have
considered.
already
You have participated. Now you have to consider his candidature. If he is eligible, 19, 20, 21. ওটা হচ্ছে ডিপ্লোমা ইন এলিমেন্টারি এডুকেশন ফর দি সেশন 2019-2021 যেখানে ট্রেনিং এর কথা বলেছি। Results were declared on 29 July 2022. Next.
Deeply obliged.
Yes. At 44, I beg to appear for the petitioner. My lord, on the last occasion, my lord was pleased to direct the board to file a report. My lord, if board is filing the report, then my lord, I will. No, it was specifically mentioned that the board has to file it. 19th December 2025.
Yes, taken the response.
So, my lord, if they are filing the report, then the matter can be proceeded.
From the association. Oh. You have intimated the secretary.
Yes, my lord, we have intimated, but the difficulty is we have the receipt in the, in the mobile. We do not have the hard copy today.
Where is the report? Organizing teachers when the matters coming up.
That time board was not there. It is the state who need to answer, but as lordship, it has fallen for your lordship to Mr. Bishas to file a report, or we will file a report.
Oh. Mr. Kaushik Chaudhary, learned advocate for the board, seeks extension of time to file report. অনেকগুলো মামলা করেছে এখনই চাই।
My lord, may I submit one thing, my lord? No need.
File a report within a period of 2 weeks.
Oh.
Please this matter after এটা মোশন থেকে সরিয়ে দিন হিয়ারিং এ নিয়ে চলে যান Learned advocate for the petitioner is directed to intimate the Secretary State Legal Service on the next date of hearing.
Yes, yes.
What is this can one?
Yes, yes.
Yes, can one is, my lord, some similarly situated persons, they, my lord, wanted to be party as a added as a party.
You have filed it.
Yes, my lord. Let that be allowed. Similarly situated persons, somehow they, my lord, at the time of filing the writ petition, they could not have been contacted. Now, my lord, they have come up.
Some were minors.
No, my lord, that is, they are saying that will be revealed once the report is filed. But this can, my lord, we have filed for addition of party.
What will reveal?
Petition কয় ফাইল করেছে কয় ফাইল করে
না না সেটা তো ওরা বলবে
কয়
আগে কয় ফাইল করেছি আমরা
Some of the petitioners were found to be minors.
Yes,
lordship. That is their submission on the last occasion that some of the.
Sir, what submission?
This is your my lord has
You have stated the age of petition number 5 as 47. And when the Honorable Supreme Court is passing the order in which year it was passed?
My lord. But my lord, considering all those aspects, my lord directed them to file. I understand, my lord. Maybe some of them were minors.
If it is found that they were minors, they are not entitled to that.
Absolutely.
The prayers of the others will be considered. But why this application is filed by the minors? Why they were claiming as organizing teachers when they were minors at the time when the Honorable Supreme Court passed the order? Why they are pursuing this?
I will take instruction regarding this.
This was indicated on the last date. Learned advocate took an adjournment for taking instruction.
Yes.
After going through the order, I find that the similar thing is there. 47, 45, 43. This 10. When was the order passed?
My lord, on 19th December 2025.
Honorable Supreme Court passed an order.
The Honorable Supreme Court passed the order on, my lord, 3rd May 2018.
No. Wrong. Okay. This is going on since long. When was the earlier order passed? Initial order.
Order আছে
When was the initial order passed?
28th January 2016. I'm getting one order.
না এটা কারণ আছে এটা পয়েন্ট আউট করেছে ওই জন্য আমি এমনি একটা করেছিলাম আমি করেছি তাতে কি আমি এমনি বলতে পারবো রিপোর্ট দিলে ওরা বেশি
What is the age of the petition number 5 in the year 1998?
But I will ascertain.
If on the date of filing of the writ petition in the year 2020, he is 47, then what is his age in 1998?
He should have been a minor.
Minor.
Should have been a minor.
Come to page 49 of the writ petition. Page 49 of the writ petition.
Yes, minor.
When was the writ petition filed before the Honorable High Court? It is 1998.
Yes, 1998.
So what will be the age of this person? 45 যদি হয় which is a 45. Ascertain this কবে দিলাম? Under the heading hearing. Take instructions, come back with regard to this age, because this was indicated by the learned advocate for the board.
Definitely.
Because they cannot pray when they were minors, they cannot claim as organizing teachers.
Definitely. After 2 weeks. 45.
My lord, I'm appearing for the state, my lord.
I'm appearing for the petitioner, my lord. 2009, my lord, selection process of primary recruitment of primary teacher, my lord, 2009, my lord. Petitioner, my lord, was allowed in the interview, my lord, followed by, my lord, the previous examinations, my lord, the academics examinations, my lord, and her name was not included in the final panel, my lord. The DPSC was, my lord, directed, my lord, to file a report as to whether why the petitioner name was not included.
Yes, Mr. Prasad.
Your Lordship, the very maintainability of the as of now, my lord, there is a direction for filing report. My lord, it is not with me, but I am also, my lord, the writ petition was filed after the cut-off date fixed by the Honorable Single Coordinate Bench with regard to Malda district. It is filed on 27th of February 2025.
My lord, Annexure P5, the writ petition, my lord, of 2015, where the petitioner was the writ petitioners, my lord. One of the writ petitioner is this writ petition, my lord.
Which one?
Annexure P5, my lord, page 21, my lord. ফাইল করেনি নট টু মেক ছিল।
Yes.
Yeah. Now, my lord, here, my lord, what Sanjeev Kumar Mondol and others, this is a writ petition where, my lord, the cause title is Sanjeev Kumar Mondol and others. And, my lord, it was disposed of. And now, my lord, the particulars that has been, my lord, annexed in connection with the, my lord, direction passed by the Honorable Single Bench in the writ petition that was referred to your Lordship, that is page 20. This was also addressed to Sanjit Kumar Mondol, son of Nukul Mondol. Here the petitioner name is Moshumi Mondol. Now, my lord, what I am praying before your Lordship, my lord, I am seeking to file an opposition in this matter. Let me give that liberty so that I come back with an opposition. Let it be decided on affidavit.
My lord, it can be sorted out. This writ petition, Sanjit Mondol and others, let that petition be brought to before your lordship. Everything will be clear. Whether these are petitioners or in that writ petition or not.
Mr. Abhishek Prasad, learned advocate, appearing for none. Gautam Babu. Mr. Abhishek Prasad, learned advocate, appearing for DPSC Malda, seeks to file affidavit in opposition to the writ petition instead of the report in the form of affidavit, which was earlier directed by this court. Let such affidavit in opposition be filed.
3 weeks. 3 weeks I am seeking, my lord.
1 week. 2 weeks ago, 5 weeks for a hearing a date.
I'm grateful.
2 weeks to file reply.
My lord, the advocate of this for the state name to be recorded, my lord.
নামটা রেকর্ড করে নাও।
Drag করতে চাই।
Stated advocate. Next.
Same. চুলটা করে
40 আগেরটা 40 টাকা।
Petitioner, kindly seize the fate of the petitioners, my lord. My lord, but the first time the matter was taken up
on 25th March 2025. Innocuous prayer, my lord, kindly comes to page 29. A provisional DLED certificate was issued. Now the main DLED certificate is not being issued on the pretext that the senior secondary examinations, the improvement certificate has not yet been verified. Kindly comes to page 29. Kindly sees last result pass subject to verification of class 12 mark sheet from concerned state nodal officer. Now kindly sees subsequently I completed my lord, enhanced. Page 31 is the senior secondary school examination certificate, my lord. The requirement was 50%. I have got 67%. Now, my lord, these now kindly comes to page 35. Though that relaxation, that 50% was also relaxed, kindly comes to page 35. This is a communication of 2023. The certificates after 2019. Application of 446 candidates for verification of mark sheets. This is being addressed from the state coordinator and nodal officer, NIOS, School Education Department, Government of West Bengal, to regional director, regional center, such and such. With reference to the above mentioned subject, application for 446 candidates sending herewith for kind perusal, as NIOS is the examining body and maintaining all data based on examiners, request to look into the matter and take necessary steps for verification at your what is this, at your office. Certification to this office in review. Now kindly sees my name would be appearing from the list which was sent for verification. Page 36, serial number 44. 36A is clearer copy. Kurman Ali Monla. Now, from this 2023, and the suffering is that after I get the DLET certificate, there will be a date which will be printed, which will be the date of printing of the certificate. Now, from that date, they will be giving me a category scale. Thereafter, again, I have to come to this honorable court saying that no, I am entitled to the 8 category scale in accordance with the division bench order. So therefore, until I get the certificate, I am not even being able to pray for a category scale. Everyone has got
Verify it. Let it be verified, and if it is found to be entitled, let it be issued within a period of space.
We have verified, Lordship. What we found is the criteria was when you are taking admission, you have to have a 50% marks. If you don't have a 50% marks, you can parallelly take admission and you can enhance your marks through NIOS itself. Now, if your Lordship kindly comes to his marks HS certificate, which is page 33.
Yes.
He has enhanced it. Lordship has seen it.
This
at
has
the bottom. 23rd October 2020. Lordship has got it. Now, Lordship, kindly see, he became took the admission for the year 2017 to 2019. So, Lordship, the 12th pass certificate was required in terms of the 22nd September 2017 notification that when you are applying, you have to have that, or before you complete, you have to do this. Now, he completed in 2019, 17 to 19. That was the course structure. And he obtained the certificate above 50 is only on October 2020. So, basically, when he conducted himself, he was not having that requisite qualification.
No, this upgradation of the HS certificate has to be made within which period?
Within the period before he passes out. Because the criteria is to get admission 50%.
But this is a...
But he completed the course in 2019 and he upgraded himself in 2020. That means once he completed the course, he was not having the criteria. Now, how can I give him the certificate?
You have already given it is only for verification.
That's all right, but then in
You
verification.
please verify and say it is not your, the
Then
entire
Lordship, we
contention
will-
is erroneous.
All right, then we will.
Page 31. Oh,
Lordship,
this is
the
secondary.
kindly see.
Delaying.
Page 31 is secondary, no?
Yes.
This is not higher.
Senior secondary. Senior secondary. Kindly see space senior secondary.
So what is the percentage in this?
67.
31.
67.2.
Page
Page
31.
31. Yes, yes.
Now what is page 33 then?
That is the certificate. This is the mark sheet. This is the
Oh,
certificate.
Same.
Same. And my lord, kindly sees, my lord, what is
Banerjee,
being said, my lord, kindly comes to
probably
page 34.
It will be
This has
required
50%.
from your end to verify on which date he completed. Because see, the senior secondary mark sheet is issued in the year 19.
Lordship.
Again, the certificate which you have referred at page 33,
20.
it is 20. So,
Lordship
first of all, there has to be a conclusive date on which he completed.
Lordship
Might
can
be-
do one thing. Lordship, this is a factual narration. We cannot both go into this. Lordship, my regional director is the man who sits at Calcutta. He can give a hearing. Let's fix a date in this week or next week, Monday. We will give him a hearing. We will ask him this question. He puts the original document in front of us. We will there and then and
I fail to understand, my lord. This is only for we have taken the test in their center. They have to say as to whether he has taken the test or not. Why he is going into my eligibility? This is not in question.
So,
There are hundreds, thousands of people who,
verified?
if this is the question, if this is the understanding of the authority that I cannot conduct the DLT until unless then there will be thousands of matter before a lordship.
we will
This is
face it.
this is the, my lord, procedure which was followed. Kindly see subsequently page 34 also kindly sees. Difficulty is that, my lord, one individual case, one stand is taken. Kindly comes to page 34 also.
Yes.
He is trying to going into the merit, so therefore I am showing it. Kindly sees. This is a subsequent relaxation. NRC constituted as such and such emergency meeting, which says where any requirement of minimum eligibility for admission to DLED program, that is 50% in class 12, to the extent that those who do not fulfill this requirement shall be allowed to take provisional admission to the program of INOS.
Yes.
Mentioned in clause such and such is hereby relaxed and substituted as minimum eligibility for admission to DLET program shall be passed in senior secondary. This was subsequently relaxed. The provision was that if you don't have what he is trying to say, that since I didn't have, I have taken admission, I ought not to have taken the admission. That is the contention which has been made, which is contrary to their own circular. Kindly sees.
That circular is
That was
2022 circular, my lord.
Kindly sees what is being recorded. Kindly sees. What was the requirement? May I just place the entire thing or may I just place it? NRC constituted a case of NINOS in 372 meeting held on such and such and decided that the condition, this is the condition when I went in, any requirement of minimum eligibility for admission for DLET program, that is 50% marks in class 12, to the extent that those who do not fulfill this requirement shall be allowed to take provisional admission to the program of NIOS. So that was the condition when I went into NIOS, saying that even if you don't have, I have the other circulars also, I'll draw your lordships, you can go in and you can take admission. That has been relaxed in 2022, saying that is hereby relaxed and be substituted as quote unquote minimum eligibility for admission to DLET program shall be passed in senior secondary. This requirement as of today is not there, that you have to give 50%. But any case, since I have taken the course, they only have to say that yes, this certificate is genuine. Why it is being gone into that I cannot go into the program? Kindly comes to the previous circulars also. 2017 circular kindly comes. Page 19.
I think page 25.
19 or 25?
25. That.
Yes, 25 is also there.
Now you come to page
Page 26.
bottom.
Yes.
Now read.
Next week, you file your report in the form of affidavit. Whatever you have to say, you say.
My
Let it come.
the scope is only verification.
Lordship,
Can
kindly-
you see the last page?
I understand. Kindly see, Lordship, page
Verification as to
26.
whether the mark sheets are genuine or not.
No,
That
what
is the
he
only
is
scope.
relying upon is 2022 circular. This is 2017 circular, which now Lordship is in hand. Now Lordship, kindly come to page 26. It starts from page 25, which come to page 26. Now page 26 says at the bottom, Lordship, if your Lordship has got it, Roman 2, the requirement minimum eligibility to admission this, that is 50% to the extent those who not fulfill the requirement shall be allowed to take provisional admission to the program, subject to their acquiring 50% before completion.
Now this has now been relaxed.
So that relaxation has done in 2022. So now what he is
This is
basically
before
want,
completion.
the way he placed it is a very innocuous, is not so. So before completion, he need to. Now he is guided by 2017 circular. He cannot take help of 2022 circular.
Then 2.
Yes, this has been done before
Page
completion.
34, clause 2.
Page 34, clause 2. Yes.
This relaxation is only for all the candidates.
Yes, but this has come in 2022. Kindly see the top. That's what I'm saying. This is 22 circular. This has come on August 2022.
No, the petitioner has also completed within timeline.
No, yes, but
DLED has been completed within timeline.
Yes.
No.
So it says all candidates, does not say that prior or after.
It cannot give a retrospective effect.
So
My lord.
then
No
why this-
notification.
Why this clause is there?
But-
All
there are
candidates who have
thousands of
cleared
cases
DLED
like
should be
this.
given
No,
that.
if he wants to
Those who
open
have
all
come
these
to that, now,
things,
please understand, Lordship. Suppose
this is the procedure. They were responsible for that.
Now it is your notification.
Mine.
Says
It
that
cannot
all
have a-
candidates. It
Lordship,
does not say. It doesn't
His
say
everything is over. His everything is over in 2020.
Huh.
Now, subsequently, a notification is come 2022. Maybe in 2029, another notification will come. No notification have a retrospective effect, Lordship. No law or no notification can have a retrospective effect.
So how do you say that all the candidates?
All the candidates from that date. That is from 2nd of August 2022.
What is this?
No.
All the candidates from that
The
date.
pass certificate which has been issued after completion of DLED is, it will not be acted upon.
Because 2027 certificate says that before
Then
completion.
again they have to take an admission for a 2 year course.
Kindly
But
see
you kindly
page
see.
30. It was completed
If the-
prior to that. Kindly see page 30.
What is the process to be adopted?
They
To have
entire thing was done.
Sir, please.
Yes.
To have a candidate, a qualified candidate to teach the
First criteria is he has to has a 50% marks in HS, so he can get it. Now, what was the relaxation in terms of 2017 circular? Lordship, kindly come to page 26. The requirement of minimum eligibility admission to DLED program, that is 50% is this. To the extent those who do not fulfill. Now, if the case comes, those who do not fulfill. Now, those who do not fulfill this requirement shall be allowed to take provisional. So, I have allowed him to provisional. To the program, subject to acquiring their 50% marks before completion of DLED. So, Lordship,
Mr. Banerjee, a request to you.
It has
Just
already
clarify from take instruction, because that particular clause 2 also goes on. It says that this relaxation is not a complete relaxation. It's just a one-time relaxation.
but that, Lordship, kindly see the circular of 2022 is a circular. Now, no circular, no law can have a retrospective effect.
That is, I'm reading from your. This is a one-time. It is not that after 2020
Even-
it has been relaxed
Sir,
forever.
Lordship, no one, no circular.
Then what
That
happens
is
to
a
the person
basic
who has
principle of
completed
law.
that?
Now, my lord,
Lordship,
kindly see,
basic
this
principle.
was done prior to the completion. They didn't give the certificate. Kindly comes to page 22.
You file it.
Lordship, I will. That will make the
Examine
matter
the
more
rules.
complicated. What I suggested is, instead of
No,
I
no
say-
hearing. I am opposing that. They will give the hearing, they will go that you are not eligible, all these things will come up.
All right.
It has to be.
I'm
Kindly let them file a report, my lord, kindly.
No, Lordship, I will file a, instead of report,
Opposition.
I will give it to opposition because.
No, opposition will be, that will be taking up to hearing. We are from 2023, you have
No,
not
I
been
have
able
to.
file.
Why?
But
They let them deal with all the pleadings that you have made.
let them
us
come up
examine
with the
that.
report.
Why?
It will
If
already
I have
If
to.
it's report,
thing is-
then my lord,
Lordship, there is
what
no
they are trying to,
factual
what
dispute.
learned senior friend is trying to do is drag me to hearing list. Why they will do so?
No,
Being an
let it be in a
authority,
motion list, but use me, allow me to use opposition.
report in the form. That is
Why-
only
why
a
not?
Deal your
documentation.
averment then.
Don't deal.
Like, why-
It
why
is
you are
merely a
opposing
point
this?
of law.
So all this
Not shy out from that.
Next,
You should not.
he will say that this is an opposition, this is a hearing matter, let it come in the hearing list.
No, he will say I will put it under hearing, or it is for the prerogative of the court to
No, he may
consider
praise,
person or
he
hearing.
may praise so.
He can praise, yes.
So
Let him
today also I am
consider.
praying for dismissal. Will not happening.
Mr. Shiv Shankar Banerjee, learned advocate for the respondent in NIOS, submits that the petitioner ought to have completed / upgraded his HS qualification with prior to completion of
This has been done. Kindly see, it is
DLED,
appearing from the record itself.
DLED.
The last date of examination was March 2019. They didn't issue their certificate.
He seeks to file an affidavit in opposition dealing with the pleadings. The hearing at listed দাও এবং definite date দাও যেদিন হয়ে যাবে
My lord, would your lordship see two pages? I understand, man, what he has said. Kindly see page 22. What was the date for completion of the DLET? It was March 2019. Now kindly see page 30. What were the dates for examination? March 2019. Thereafter, so it was completed. Examination complete. The certificate has been issued in December 2019. December.
And when you completed your course, prior to December or after December?
It is your thing. If you give the mark sheet as of today, so therefore it will constitute that I have not completed DLET.
Because the country could go ahead, only this petitioner could.
একটা কোনো জায়গায় ছোট জায়গায় মোশনে রান করুন 3 সপ্তাহ ডেট কাম আপ আন্ডার মোশন ঠিক আছে 1 week give advance copy of that 3 weeks পরে মোশনের আন্ডার লিস্ট করো একটু উপরের দিকে রাখো কবে আসছে 13th
Next also, my lord, same matter.
Huh?
Next matter, 58 is also same.
58 with Ahmed. 58 key instruction.
Opposition 2 weeks, 1 week to file reply, advance copy, motion 13th April, top.
Not a clear action. Same thing.
To be included under the heading motion, my lord.
It will be under the heading motion. Let him file the opposition and reply.
58 is also taken.
No. I'm not passing any order in 58.
Malad, item number, Malad,
He will take it up.
Malad, item number 25 to 31 kept on 20, Malad. Item number 451 and 452 is a similar matter, Malad.
No, I cannot allow mentioning.
Malad, I am not mentioned it, Malad. I am just saying that item number 451 and 452 kept it on that day, Malad. And already I communicated to Mr. Bishas as
Which date?
on 20 April, just 20 April. Item number 25 to 31 kept on 20 April, my lord. So item number 451 and 452 is a similar matter kept on that bench, that month. 450. Item number 451 and 452 both are regarding TET 2022. My lord, that is expert opinion challenge matter. Tagged with item number 25 to 31. Kept on 20. And I already made communication with Mr. Bishas. I talked to Mr. Bishas and as well as the state administration.
My lord. On that day you mentioned. On that day you mentioned.
Yes, no, my lord. I will make notice to Mr. Mr. Shaha as well as Mr. Bishas.
Board is not there.
I gave notice to the board also, my lord. And
there are certain directions issued in that. So your will be taken up separately. We'll see.
My lord.
Not now.
My lord,
otherwise, my lord, it will continue.
No. It will be cumbersome. In 26 you file, then again after your some XYZ will file, then again he says that the matters are same.
My lord,
Then
because
no
of that,
matters
my
will
lord,
be-
otherwise, my lord,
Because
separate.
there is a direction in that. Already affidavit in opposition, they will be filing a reply. So stages are different.
My lord,
We'll assess that.
it will covered, my lord. Otherwise, my lord,
See.
give an opportunity of hearing, nothing more, nothing less, my lord. So other, my lord, I
Come up on 20th. Those matters come up on 20th.
I am saying that
My lord,
kindly came,
my lord,
my lord, along with
my
this
lord,
matter, my
Thank you.
lord.
my lord, item number 42, my lord. One small mention, my lord.